Good morning, everyone. It's 9 o'clock, but at this time, we do not have a quorum. So we're going to proceed with what we can before the meeting is actually called to order. My name is Barbara Fuller, and as chair of the board, I welcome you to this January 16th, 2024 working session of the Washtenaw County Board of Road Commissioners. Our office coordinator, Erin Smith, will describe how our meetings operate, how to access the working session packet, and how you can participate remotely. Erin.
Thanks, Chair Fuller. There are multiple ways to make public comment during today's working session, whether you're joining us in person or virtually. If you're here in person and would like to make public comment, please fill out the sign-in sheet now. If you're joining us virtually, we will ask you to raise your hand at the appropriate time in the agenda. If you're joining us virtually and are experiencing technical issues with audio or video during the meeting, submit a comment in the chat feature and I will help you troubleshoot. The audio and video of this meeting is being recorded, and a link to the recording will be posted to wcroads.org in the next few days. There are printed copies of today's meeting agenda on the table near the front door, and it is also posted on our website. And now I'll turn it back over to Chair Fuller.
Thank you, Erin. At this time, I'd like to try and call the meeting to order, but we do not have a quorum. So we are going to pause until we have a third commissioner present to be able to do this. I would proceed, except that I really want the agenda to be heard by as many of the commissioners as possible, because we've got couple of important items in the working session. So if we could just pause, please. We do not have a quorum. So we're going to proceed with what we can before the meeting is actually called to order. My name is Barbara Fuller, and as chair of the board, I welcome you to this January 16th, 2024 working session of the Washtenaw County Board of Road Commissioners. Our office coordinator, Erin Smith, will describe how our meetings operate, how to access the working session packet, and how you can participate remotely. Erin.
Thanks, Chair Fuller. There are multiple ways to make public comment during today's working session, whether you're joining us in person or virtually. If you're here in person and would like to make public comment, please fill out the sign-in sheet now. If you're joining us virtually, we will ask you to raise your hand at the appropriate time in the agenda. If you're joining us virtually and are experiencing technical issues with audio or video during the meeting, submit a comment in the chat feature and I will help you troubleshoot. The audio and video of this meeting is being recorded, and a link to the recording will be posted to wcroads.org in the next few days. There are printed copies of today's meeting agenda on the table near the front door, and it is also posted on our website. And now I'll turn it back over to Chair Fuller.
Thank you, Erin. At this time, I'd like to try and call the meeting to order, but we do not have a quorum. So we are going to pause until we have a third commissioner present to be able to do this. I would proceed, except that I really want the agenda to be heard by as many of the commissioners as possible, because we've got couple of important items in the working session. So if we could just pause, please. It's 9:15 and we're going to proceed since we have 3 presentations today and we want to be mindful of everyone's time. At this point, I'm going to ask Erin to call the roll as we have it.
Chair Barb Fuller.
Present.
Commissioner Joanne McCullum.
Present.
And then Vice Chair Rod Green, Commissioner Gloria Yamas, Commissioner Jeff Smers. At this time, they're not present for roll call. And then the following directors are in attendance: Managing Director Matt McDonald, Director of Engineering Brent Schlack, Director of Operations Adam Lape, Director of Finance and IT Dan Ackerman.
Thank you very much. At this point in time, we would turn to public comment. Erin, if you would describe how that works, please.
Since this is a hybrid meeting with both in-person and virtual attendees, we will take turns between those attending in person and virtually. For virtual attendees, we have provided some instructions on the screen on how to participate and make public comment. If you're attending this meeting virtually and would like to make public comment, please raise your hand now. If you dialed into the meeting from your phone, you can raise your hand by dialing *9. Our communications manager will unmute virtual participants with raised hands one at a time and will announce your username or last 4 digits of your phone number when it is your turn to speak. And then please share your name and address before beginning your comments. And then for our in-person attendees, we will start with those who signed up on the sign-in sheet. If you didn't sign in, you're still welcome to make comment. At this time, there's no one that would like to make public comment in person or virtually.
Thank you, Erin. I just want to note that we do not have a quorum, but this is a working session, not a board meeting per se. And no decisions are made during working sessions. So we are going to proceed with the agenda as presented, and I will turn this over to Matt Washtenaw, Managing Director.
Thank you, Chair Fuller. Today we are, we've got a full agenda. First up, we are going to talk about a draft CDL training policy, and here with us today is Nicole Peterson, our HR manager. So I'll turn it over to Nicole.
Morning.
Good morning.
Have my PowerPoint come up? Okay, thank you. So this is a top,
Identify yourself for the record.
thank you, Nicole Peterson, HR manager. What I'd like to talk about today is a proposal for a policy to go before the board in the future. And that would be a commercial driver's license training policy. This is a topic that has been in discussion for some time, whether it's been with the board or behind the scenes as, you know, senior leadership. And so what we've put together is a training policy that would be a training that would be completely covered by the road commission for payment for them to attend the school. They would do said training during working hours because they would be a full-time regular employee for us. So 15-day CDLA manual program, which would meet our requirements for hiring a heavy truck driver, heavy equipment operator.
Go ahead.
Thank you. Would be for the manual because we do hire without any or people with CDLAs that don't have any exceptions. So we need that full gamut, and they would then need to just go and get their tanker endorsement, which is a written test at the Secretary of State. So this 15-day program, that includes 50 hours of classroom time, which includes learning about pre-trip, 50 hours of out on the range, so they call it skills, and then 50 hours behind the wheel driving.
Would you repeat that, please?
50 hours of classroom, 50 hours of range skills is how they list it, and then 50 hours behind the wheel training.
Thank you.
This is with a company called TrainCo. And I'll get into this further, but TrainCo has a relationship with Washtenaw Community College. So the classes would be held here locally. They have their 2024 schedule out. We have a personal contact with individuals there already and a relationship. So we're excited about this.
I have a question, if I may stop you briefly. I see that this is proposed as only for existing employees. Can you describe the rationale behind that distinction?
Yes. So what our thoughts were is, and Adam and I talk about this a lot, is being able to hire somebody, you know, that is the best fit and the best person for our organization. And from there, we can train them to be who we need them to be with the skills here. What we would do is hire somebody in. Our plan is, if approved, that we could hire them as a laborer, which is available in the contract. Have a position as laborer that just requires a driver's license. We would then have them here as a regular full-time employee that we have chosen, that they have passed the drug screen and physical and all the requirements and background that we have. They would be able to start learning about us, about our, you know, driving, things like that, our, you know, our trucks and all of our processes and procedures. We would put them through the program. We have in the policy where we would have expectations of if they left within a certain amount of time, that there would be an amount owed back to us. it would also be within their offer letter where I can put stipulations that this must be completed within a certain time and it must be passed. Being a full-time employee also gives them the opportunity to drive along with our current drivers
Mhm.
to help, start to develop those skills and that knowledge before they even take the class. Because the class is, being a 3-week course, we have to get them into whatever the closest or the soonest one that is available. But you'll have a time gap where they can still continue to learn and be a part of our organization.
And as I understand it, this training, if they're, first of all, employed by the Washtenaw County Road Commission and are accepted into this training program, that they will be paid while they're in the training.
Correct, that would be their job assignment for the week.
So in addition to the $5,335 investment that the Road Commission would be making in tuition for these individuals, they would also be paid while they're in class.
That's correct.
Very good. Commissioner Green?
Good morning, and I apologize for my tardiness. What are the job duties of a laborer? I wasn't aware of their classification.
Yeah, we don't have anybody in that position at this time. We do have 2 light truck drivers that only require a CDLB. So still, anybody that we have here, like facilities, the sign shop, they only require CDLB. So even they could go through this program and be able to get their CDLA and move to a heavy truck or a heavy equipment position that's open here at the Road Commission. A laborer only requires a driver's license. What we can use them for, it's like our temporaries that we have sometimes, like summer students. They can drive, a regular pickup. They do flagging. Right now, we have a laborer or a temporary laborer that is assisting in the sign shop. So even there's a vacancy there, and the CDLB holder is the one that has to drive the truck and do all that, but that doesn't prevent them from working alongside the sign erector for replacing and installing signs.
So it's an entry level position. They
Okay.
pass the drug screen and have an
Sure.
active driver's license, essentially.
Correct.
How many slots are there in there?
We don't have any right now. That would be something for me to work with the Director of Operations, Adam Lape, on possibly taking a current vacancy of a heavy truck driver, changing that on the org chart. I'm not looking to add any FTEs, but changing that on the org chart to be a laborer so that we can start to use that as our funnel for getting people into and trained up to be a heavy truck driver. And once they get their A, then they can choose on where a vacancy is that they'd like to go or bid.
And is there any possibility that at some point it might be expanded to include non-employees? Is that a possibility down the line? I'm just wondering.
No, and I say that because what we're treating this like is like a tuition reimbursement program. So, we don't, where someone comes in, you need to have the minimum qualifications. I don't know what the benefit would be for us to pay for somebody that's not an employee to get their CDLA. There's a lot of benefits, obviously, on being fully employed here and being an employee. So tuition reimbursement, obviously, you pay the money up front, and then we reimburse you when you've completed with a satisfactory grade in your course. This, we're just going to pay for it up front. It's your job responsibility to complete the program, and then you have your new credential.
So they have to pay the money up front?
No, not for this program. We will
Okay.
pay for it.
I see. Okay,
I
thank you.
will
very-
enroll them in the course.
So
Thank
we
you.
would pay WCC or Train Code directly
Yes,
for someone who's enrolled in the program.
Okay,
Unlike, say, if one of our employees wanted to pursue a degree,
right,
they could take a class,
right.
successfully complete it, and then we would reimburse them
I see.
for what
Okay.
they invested in that class.
Okay.
This is a unique proposal.
It sounds very interesting.
Yeah, we don't, so I mean, I think there's a lot of ideas out in other road commissions and where, it's, we're definitely all short-staffed. CDL qualified CDLA holders is difficult to come by. There's a lot of competition. There's a lot of vacancies across the United States. And rather than doing it in-house and taking away where we're already maybe overworked and understaffed, having this partnership that we can do with Washtenaw Community College, with Trainco in our backyard, they'll hear the same message. Everyone's getting the same training. They're using the same trucks. They're organization's up to date on the latest and greatest of all the laws and rules and everything that goes into it. It just made sense to us on let the experts train them. And then we will train them on all the other things that are unique to our pieces of equipment.
It's a start. Thank you.
Oh, it's a huge
Very-
leap.
yeah.
Commissioner McCollum.
Okay. So when they successfully complete getting the CDL, then do they get a promotion or do they get more income from that?
Yep, they would become a heavy truck driver. So typically our vacancies seem to fall either in state trunk line or at District 2 at the Southeast Service Center. So they would have the opportunity to choose what works best for them. It may be location or their interests, and we'd be able to place them into one of those positions.
Thank you.
Also want to note that if we have one or two individuals who express an interest in this and are eligible, it makes more sense to partner with WCC and Trainco to do this than try to stand up a program here and pay for it and staff it and underwrite it completely for one or two people. So
Right, and like I said earlier, this is for existing employees as well. There may be a position, that currently has a B, and if they want to move in, we have 2 light truck drivers that we hired with the intention of kind of this idea. But they were gonna go on their own to get the A. And, when you're a new hire and now I have to come up with over $5,000, I have to have all this time, even if we offer to have them take it unpaid, to be able to spend 3 weeks at school. So now I'm not getting income for 3 weeks. It was just too much of a hardship on the employee. So that's how we got trial and error a little bit on how we got to where we are today.
and do you envision, oh, I'm sorry, Commissioner
go
Green,
ahead.
go ahead.
So just for clarification, so someone comes in and say, as a light truck driver, they don't need a CDL,
A light truck driver needs a CDLB.
or
A
they do.
laborer needs a driver's license.
Okay, so at the bottom rung, what's the minimum requirements for someone who comes into the road commission,
A driver's license,
driver's license?
And passing the drug screen and the other
background. and-
physical-
Yes,
assessments and such.
correct.
Okay, okay, sounds good.
And as I recall, benefits initiate immediately upon being hired.
Yes, day
Right.
one,
Right. There's no window where you're,
as far as like medical and
yeah,
that sort, yeah.
Yeah.
Okay.
Careful.
Mr. Director.
Yes, so this is a change in our organizational practice. In our contract with TPOM, we do have the laborer position. However, currently in the org chart, we do not have any laborers listed. So this would be a change in practice. So these questions are very valid. The idea, as Nicole will get to in her presentation, as we get back to it, is the realities of our workforce and the ability to fill these vacancies. We had to change our mindset, and we need to really, this policy will be a great tool for us to get access to employees, potential future employees, like starting out as a laborer, or we've begun that with the light truck driver. And once they get that training done and have that CDLA license, they would then bid into other positions in the organization. And then we'd have a vacancy for light truck or laborer. And then again, we would then post those internally and externally so that we could bring others into the organization. So that really is the way and line of thinking to solve this issue of our vacancies.
Okay.
Kind of grow our own. It's a farm team.
Correct. Correct.
Yeah.
Yeah, very much.
Good
And,
concept.
you know, when I have here on the slide who, and talk about attract a more diverse workforce, you know, there's those that don't have this available to them that we would be able to provide. We attend the Celine, like job fair for the consortium, can't say the word, that's within Washtenaw County. And we get students coming up to us, you know, male, female, that are saying, I'm not going to college, what could you offer me? And previously, you know, it was like, well, if you go get your CDL, here is what we have. But now we can, you know, have a different take on it and hope to go in the spring again this year and say, we will train you, you know, if you're the right fit for us and this is what you're interested in doing. So really excited about it.
And if I could just add to that, during the summer, oftentimes we're hiring temporary employees for flaggers. And that gives them a taste of who we are, what a career path could look like at the road commission. And so I think that is, again, another opportunity where we could say, we may have a labor position open up, and then we will train you to be our road warrior or road commission employee that essentially you can grow a career here at the road commission.
I think it's an exciting innovation. Commissioner Green.
And so it sounds like a temporary employee could possibly move into a laborer's position, which is permanent
You're welcome to apply if we have a vacancy.
if there's a vacancy, and then take the benefit of the training. Now, I apologize if I missed it. What is the role of Washtenaw Community College in this?
It's hosted at their site.
Oh, I see. Okay.
So
We're
it-
doing the
it-
training?
It actually, it's, so I can,
TrainCo is doing the training.
Oh, I see.
so here I have,
It's
if
like
we,
All-Star Driver's Ed,
Uh-huh.
only this is TrainCo for.
Oh, wow.
so if you can see right here, right on Washtenaw Community College's website,
Okay. very
we
good.
have the TrainCo truck driving school that they advertise and the programs. And then when you go directly to TrainCo, they have programs in campuses. So they're doing Monroe Community College, Washtenaw, and a couple places in Ohio. So that's where I was able to bring up the new schedule for 2024. And they have monthly classes, 3-week classes.
Could you back up to the time? It seems like they start at 7:30. 7:30 to, 7
7 to
AM to
5:30.
5:30.
Correct.
So right there, that tells us a whole lot about somebody. If they can't even get in class on time, and you know how I feel about punctuality. That's something they're going to have to make an adjustment to and demonstrate a commitment
Right,
for as well.
Yeah.
that's true.
I mean, luckily we start at 7 or 6 here, so we're already going, but it is a little bit later. But like we said, that's their job assignment for the week. There are no other concerns, you know, except for that.
Other questions?
No.
I just want to say, I love this. Thank you for doing this. It looks like a lot of time in research and probably meetings and all that went into this. So thank you so much.
Thank
And
you.
I'd also like to add my thank you as well. I think this is a great start. It's very innovative and creative. And I know that it's kind of a leap of faith, but I think it's in the right direction.
I think it'll be worth the investment. I know it sounds like a lot of money, but I think, you know, with the vacancies that we have, with turnover, you know, being able to find the right people and get them trained, I think that this was spearheaded a lot and pushed by Matt, so he definitely deserves a lot of credit on it as well.
Thank you.
Commissioner Yamas, did you have a question?
This was kind of some of the stuff when we first came in, we asked about, right? And
Even
like an
before
on
that,
training
yeah.
even before that. So this is a great step in the right direction, I think. Be so helpful to us.
And I'd also, oh, go ahead, Matt.
No, I was just gonna say, so before you is the actual policy in draft format. The idea certainly resonated with our leadership team, with the support of Adam Lape and Brent Schlack. They're responsible for the departments, and ultimately there's a lot of support for this. We're excited to bring it to you for consideration. We anticipate bringing it to the February meeting, the first meeting in February. So if it's on the agenda, we can move forward with the adoption of this policy, and then we can start implementing. So we're excited about it. But we did put it in draft format. So if you had any questions, be happy to answer them after the meeting. Nicole or I can address any concerns you have with the
Commissioner Yamas.
language.
Oh, sorry, Commissioner Yamas.
So the only question I have is like the employee's not eligible for call out while attending training. My question is like in times of emergency, I mean, in the workforce that I came from, they were like they didn't use the seniority list. They were like the last to be called if there was like a snow emergency. So are you gonna, is that something you're gonna consider or not consider? Not that, like, it's not intended for somebody who always does overtime to still be able to get their overtime.
Well,
And I'm thinking about our workforce, right?
important to remember are these are people that probably only have a driver's license anyways.
Okay,
So they will not
Be
be
needed.
getting into the heavy truck
okay,
to
They're not
go and
qualified.
do winter maintenance. I
Okay.
think extenuating circumstances would probably be a case by case if
okay.
we really needed somebody to come. But what we want to do is make sure this was their focus. This was the time spent, that they're not spending 4 hours out on a call and know that they have to go back to class from 7 to 5:30.
Yeah,
Want to make them as successful as possible.
well, that makes sense, absolutely. So I was thinking about our workforce, but that certainly makes sense. They won't be able to get in the trucks anyway.
Yeah, we had the same conversation at the leadership team. We were debating that
Yeah.
same point that you brought up. So great question. But typically that's going to be the laborer, so they wouldn't be eligible. We wouldn't be taking a truck off the road, so that they're going through this training. That's absolutely not the case. They
Okay.
wouldn't be one that is behind the wheel of one of our heavy trucks doing winter maintenance.
Great, thank you.
And I just, on a personal note, if we're inundated with applicants and you're like, ooh, we don't have slots for them, please come to us and ask for an allocation to enable anyone who expresses an interest and is eligible to be able to take advantage of this position, because we are in desperate need of drivers and have been as long as I've been a road commissioner. So don't be constrained by the org chart.
Well, thank you for that. I appreciate that.
Anything else on this? Anything else you want
No,
that we've,
not today.
Matt, anything?
No,
On
I
this
think that
matter.
concludes this topic.
Okay,
We look forward to bringing it
Thank
to you in our first member meeting in February.
yes.
Great.
Thank you. Thank you.
Thank you.
Very exciting, very exciting.
Yes, yay.
All right, next on the agenda, we have right-of-way condemnation proceedings discussion. And start off, our Director of Engineering, Brent Schlack. And also we have Mr. Dan Troika with us to help with this presentation. And I also in the background, and I'm sure Brent will mention this, our right-of-way specialist, Kurt Brochet, was instrumental in guiding us through putting together the slides for this presentation. Go ahead, Brent.
Thanks, Matt. Good morning, Commissioners. Brent Schlack, Director of Engineering. Yeah, we're gonna go through the condemnation process, but before we do that, and I'll introduce Dan and Kurt coming up, but before we do that, there is a whole process that, or I guess first let me go through the agenda. So we'll talk about a little bit about the road improvement project process, and then we'll get into the condemnation, and Dan will come up and talk in depth about that, and then we'll have a summary, then our Q&A. So the road improvement project process. So there's a whole part of this that starts before we get into condemnation. And we actually have in our May working session, we'll go into a little bit more detail on what that, what a project, the life of a project looks like. So that will kind of foreshadow that a little bit. This will be coming up in May, but so as we look at a project, it mainly starts with our funding year. And that's whenever we, are able to, either through a grant or our federal funds, and it starts with whenever we, get that funding is allocated towards a year. Then we look at our construction schedule. Our schedule is what dictates a lot of our process. Sometimes we have to work that schedule backwards, and you'll hear some of that from Dan coming up. And that works into our right-of-way needs. So then we, as we work that schedule backwards, we're looking at our bid date, a bid date, then that kind of sets us up for what our requirements, how Dan and Kurt get set up through that possession of land and what's required for that. See if there's anything else for that. So as you'll hear Dan, whenever he does this presentation, so in order to acquire land, we need to determine what those needs are. And that's what whenever we're developing our plans and through that process, that then sets Kurt and Dan up for either Kurt mainly, but then if we need to bring Dan in, we bring Dan in to then acquire the appropriate pieces of land for our project. So with that, I'll just introduce Kurt. Kurt Brochet, he's our right-of-way specialist here at the Road Commission. He's responsible for securing various property interests from a multitude of property types, including farmland, residential, multifamily, commercial, and industrial, which requires an understanding of the unique aspects of each property type. Kurt is a licensed real estate salesperson and limited appraiser in the state of Michigan, and a designated senior member of the International Right-of-Way Association with a combination of 24 years of experience, with 18 of those here at the Road Commission. So unfortunately, Kurt couldn't be here. He was sick, but I think he's joining remotely, or he was going to try to. And then alongside Kurt, so Kurt mainly starts that process for us, and then he brings Dan in whenever needed. Dan's an attorney with Conlin, McKinley, and Philbrick in Ann Arbor. He graduated from Boston University School of Law in 1994, and he practiced in Boston for several years before moving to Ann Arbor in 2002. His practice specializes in real estate and commercial litigation. He has represented the Road Commission in condemnation matters since 2005. So with that, I'll bring Dan up, and Dan can then go through our process of condemnation.
And what is forward and backwards?
So I just down is forward, and I don't know if you like it. So this is in the presentation mode. I can just do it the other way if you'd like.
That is fine.
Okay.
Just want to make sure. I have the
Yeah.
right
So
button.
yeah. So just hit the down and up. We'll move you through the presentation.
All right, thank you.
All right. Thanks, Dan.
Good morning. I appreciate you having me in this morning. So I'm here to talk about what happens when the lawyers get involved. Most cases, that's not required. Most of your projects, I see them as a consumer out on the roads, but fortunately, I don't get a call because for the most part, the Road Commission, including Kurt, does this job well. They work with property owners to arrive at a fair estimate of just compensation. They pay them, doesn't come to me. However, when we cannot reach agreement with the property owner for right-of-way that we need for a project, we may then have to invoke the power of the law to go forward to make a project happen. When you think about it, it's necessary that any public agency that uses land have the ability in certain circumstances to take that land over the objection of an owner. If you didn't have that ability, you couldn't have a train, you couldn't have a highway, you really couldn't have anything. So there has to be an ability for this to happen, but it's an awesome power. If government can just go and take what it wants with no protection for the owner, then you are approaching one of the badges of tyranny that our country was founded to fight against. So how do you deal with this? You deal with this through the concept of eminent domain and condemnation, which is the same thing. So eminent domain means that the government ultimately has the right to take property for a public purpose over the objection of private property owners, but it must be done for a public purpose and it must be done upon payment of just compensation. And those rules are encoded in the United States Constitution, Fifth Amendment, as well as Article 10 of the Michigan Constitution. So we are operating in a sense, in a constitutional domain when we take property, and we as an agency have an obligation to be protective of the rights of owners. We're not there just to get our way. We are there to provide just compensation and to negotiate to the extent we have a disagreement. As mentioned, the definition of eminent domain is the right of a government body, which we are, to expropriate private property for public use with payment of compensation. And the phrase that is used in the practice of the law is just compensation. How do we do that? Well, in Michigan, since 1980, there's been a statute passed by the Michigan legislature, signed by the governor, which outlines the procedures by which we can take private property for a road project. That statute is called the Uniform Condemnation Procedures Act. And whenever you talk about condemnation and the rules governing it, usually we're actually talking about that act and the procedure it outlines, and often technical requirements, because this is an area of law that has a lot of technical requirements consistent with the duty of protecting property owners while allowing a government body to go forward and do what it needs to do. As mentioned by Brent and as indicated in this slide, before it comes to me, before we start a compulsory process, it is our job to go assess what it is we need for the project and determine ourselves what we think the value is of that property, and then make a good faith offer to the property owner. Typically, for the type of work we do, it's going to be permanent right of way. So we've got like, a T intersection, cross intersection, we're going to make a roundabout. You might need to take additional right of way, possibly in each of the 4 quadrants as you expand from a traditional intersection to a roundabout. So that's, permanent right of way is the most common thing that at least gets an attorney involved. In addition, if we have to stage or grade on private property on a temporary basis, we can't just do that. We either have to have an agreement with the property owner, which would be called a license, or we have to take that as well through a formal condemnation process. For the work that we're doing, whether it's permanent or temporary, if it involves taking additional property, for example, cutting down trees belonging to a property owner, which would be the case for a temporary, or removing a sign, say, for a business, well, we can't just do that either. We have to estimate the value of what we're taking and offer compensation for that. This is intended to be a cooperative process. We can't, of course, compel cooperation, but an example of the type of cooperation we'll do is if it is perceived that there might be, say, a zoning problem with the taking we're doing. If we're going to take a lot that is conforming under local ordinance, and by taking a portion of it, make it non-conforming, we might go to the local body of government and seek a variance in perpetuity so that the property won't suffer under the ordinance for that taking. That's an example of something that we occasionally do to try to mitigate loss. That serves 2 purposes. It makes a property owner happier. It mitigates the impact on the property. And then ultimately probably saves us money too, because if there's less damage, then we're going to be paying less in terms of just compensation. So we're in a situation where Kurt has done all that he can and probably has reached an agreement with most property owners, but now we have 1 or 2 who are not agreeing. This is where I come in and we begin a process which is formal and is compulsory. That begins with us coming before this body and asking for you to adopt a declaration of taking. A declaration of taking is what it sounds like. It's when you decide that we have to have certain property in order for a project to proceed. In that declaration of taking, we're required to make certain findings. One is that it's for a public purpose. That's usually not an issue for a road commission because we're building roads, and that is inherently a public purpose. If for some reason we were doing something else that did not appear to be public, it certainly could be challenged. But as a rule, what we do by definition is public. No one can really succeed in saying it's not because, again, it's roads. We have to identify in that declaration exactly what it is we're taking. Our engineering consultants, surveyors will do that. There will typically be, if it's permanent right away, a survey actually showing what is being taken along with the legal description of what is being taken. If it's temporary, it might just be engineering plans. You don't have the same necessity of having a legal description and everything done precisely. If it's temporary, you need to know what's being taken, but some imprecision is okay. And that defines what it is we're doing. If there are trees belonging to the owner that we are going to be cutting down in the process, we'll get an appraisal. Someone who will come out and look at the trees that are going to be lost and put a number on those, and we'll offer to pay that. We have to identify each of those things that we are taking in order to make the project happen. And that gives the property owner certainty. And it also allows them to verify we're compensating them for each item of damage that may happen to the property. In that declaration, we also have to identify the owner. That's fairly obvious, but in order to do that, we'll go back to assessor records and ultimately the register of deeds, which is the final arbiter who owns property. In addition, we are required to identify other interest holders. So there may be a bank who has a mortgage in the property. It's not uncommon that there are utility easements. You may see AT&T or DTE, or for that matter, the Water Resources Commissioner might have an interest in property. They have to be named in our good faith offer and in the declaration of taking if we have not reached a deal with them. In the declaration, we also have to recite that the taking is necessary. Generally speaking, this is straightforward. We have no incentive to take more property than we need for a road improvement project, but we do have to certify as a board that we've looked at the plans and have concluded that whatever you as a board are being asked to take through eminent domain is in fact necessary for the project. And then last, but certainly not least, we state in our declaration what we estimate the just compensation to be. And upon estimating just compensation, this becomes a number that essentially we are agreeing to provide. We're not going to argue over that. It sets a floor in the process. It can also be ceiling if we get the number right or if it's not contested. But essentially, we're saying that we, in the exercise of good faith and in good faith negotiations, have concluded that this taking is going to result in X dollars of damage, and we offer that. So that's spelled out in the declaration of taking. We have to record that, and that is a precondition to then filing suit. We also, at the same time, have to deposit the amount of estimated just compensation into escrow. That is, again, intended to protect an owner from a potential situation where a governing body takes something and then that later down the line doesn't actually have the funds to pay for what they took. That's not something that should happen with the road commission, but the protections are there because it's a owner-friendly regime.
Commissioner Green.
Yes.
Yes.
And what happens if there's an issue or it's unclear as to who is the owner of record?
Well, we would name anybody who a title company would say is an owner or could be an owner. So if we really had a situation where the record was unclear, and you might get that, for example, if there was a land contract seller, a land contract buyer, you may not know who actually currently is a title holder. We would probably name both. And in our good faith offer, we are able to make it what's called a unified good faith offer, where we don't say we're offering $10,000 for your interest, $1,000 for yours. Instead, we say the overall damage is $20,000, for example, and these are the people who have an interest, and you need to sort it out amongst yourselves. We will commonly do that because it's really next to impossible for us to evaluate the respective interest of each entity that has a deed or a land contract or a lease or an easement. But to answer the question directly, we'll put them both if that's the case, or everybody.
Matt.
I would just also say that prior to making that good faith offer, we do a title search on each parcel that may be impacted by our projects, so that we're very aware of as much as we can be by the title company Dan referenced. So we'll engage a title company and do a title search on any project that's or any parcel that's impacted by our project.
Right, and so ultimately we will defer to a title company. The one thing a title company may not be able to determine would be, for example, a tenancy. Occasionally leases are recorded or something called a memorandum of lease, in which case it is a record interest in the property. That's commonly done for a commercial lease over a year. But even for a non-reported lease, if we know that there's a tenant, we must also include them in the good faith offer and in a lawsuit if it gets to that. So after the declaration and recording it and setting aside the money in escrow, the next step is to proceed with filing a lawsuit in the local circuit court, the Washtenaw County Circuit Court, which has jurisdiction over any eminent domain cases in Washtenaw County. And the process of filing a lawsuit, some of it is generic to all civil lawsuits. Some of it is specific to condemnation. In the slide up, you always have to have a complaint and a summons when you commence a lawsuit. The complaint is a short, numbered set of allegations for which you are asking the court to provide relief. The summons is a piece of paper that says that you have been sued and thou shalt respond by a certain date. And if you don't, you may be defaulted. We'll do a notice of taking, which is something that is not strictly speaking required, but it's intended to put the owner on notice as to what's really happening. It's in more plain language so that maybe conceptually things don't get lost in the legalese that you see in the complaint. And then we usually do request a jury. Either party, the road commission or the owner, has a right to request a jury. We do so as a matter of course. We would prefer that a matter that issues of compensation be resolved by a jury if it gets that far. But if we do not request a jury, the owner would have the right to request one, and that would be binding on us. The one thing that is,
Commissioner McCollum.
Yes, I was wondering about that because it seems like the jury trying to communicate what's valuable to that person, their land, it seemed like they would be more apt to feel the same way because they have property. A lot of people have property, but you're saying that that's a better way to go than a bench trial?
so there's not a whole lot of data to evaluate your bench trials versus jury trials and condemnation. I will say it's been the practice, and if we didn't make that request, the defendants would probably make the request themselves, and we would be liable later on in the lawsuit for the cost. But it's a very good question, and I can't sit here and definitively say that there's a record out there to tell you which is better. But all things considered, we have been more comfortable historically, and this goes back to before I started doing condemnation for you in 2005. We have simply always asked for jury, and so do other road commissions. It's a practice, one of these things that could be reconsidered, but it's how we do things, and I guess how we'll continue to do things unless and until we learn that there's a basis for changing that. The one thing we do that is unique to condemnation at the outset of a case is we are required, and a court is required to issue something called an order fixing date at the time we file the complaint. And that is an order from the court that is served on the owner and any other interest holders, along with the summons to complaint. And that order says there will be a hearing on a certain date. It has to be more than 21 days after the defendants are served. So we'll usually pick a date about 28 days out to give us a week to make service. And that hearing is a hearing for determining whether we are going to have a right to possession on that date. And the reason for having this hearing early in the lawsuit is because we can't proceed with the project. We can't certify right away. We can't plan without having some certainty that we have the ability in terms of right of way to proceed. So if you were to not have this hearing up front, and if you were instead to take the issue of our right to possession and tie it to other issues, primarily money, it could take 2 years to get an answer. And that's simply not consistent with any reasonable road improvement schedule. So the Uniform Condemnation Procedures Act recognizes that up front there is a need for the public agency to get certainty about right of way and the ability to proceed. And that is what that original hearing is. So when you go to that hearing, again, about 28 days after you file suit, if the owners do not appear, or even if they do appear, if they do not file a motion to review necessity, then on that date, possession will be conclusively presumed and granted to us. And that's a fundamental step in condemnation. That's the point at which we can rest easy on our ability to do the project and know that the lawsuit going forward is simply going to be over the amount of just compensation and not whether we can actually have the right of way. So if someone does show up and contest necessity, typically they have to say, what you're doing is not for a public purpose, very hard in the case of a road, or they could say, for example, you're taking more property than you need. And occasionally that does come up if we need like 1/10 of an acre, and for some reason we took 2 acres, court might strike that down. We don't need it, then we shouldn't take it. But as a rule, we're not going to do that. There's no reason for us to do it. apart from it not being consistent with the concept of eminent domain, it would also cost us a lot more money. But people do come in occasionally and challenge necessity. Sometimes we'll make arguments like, we don't need a roundabout. Those arguments typically do not get any traction. The role of the court in reviewing necessity is simply to determine that it's a public project, which again, pretty much by definition the case with a road improvement project, and to assess that the actual land we've identified is necessary for that project. And the court doesn't second guess our priorities. It doesn't say, well, you don't have to have a roundabout, you could put a signaled intersection. That's not the role of the court. It's a fairly limited review, and one that is in which the court is required to defer to the condemning agency. And so there has to be fraud or abuse of discretion or an error of law for a court to overturn a decision of a taking. And again, that's extremely rare. Does happen, hasn't happened to us in the 18 or 19 years I've been doing this. If someone does challenge necessity, the court must have a hearing within 30 days of that motion. And then the court is required to issue a decision within 60 days after the hearing. So it could slow down a project by 90 days. And if so, we have to do that. But at the outside, after 90 days, the issue is going to be resolved. And if the court rules in our favor, we can proceed. If the court does not, then, well, unless we can reconfigure the project, we are not able to go forward. Again, that's never happened. In my practice, it would be very unlikely for a road commission, since what we do is sort of bread and butter public work. But theoretically, it's possible, and the law has to allow for that. So this slide I just went through, so I'll pass forward. Same here. So we have gotten through the initial part of a lawsuit. We have our order for possession. That is the point at which it becomes just about just compensation. And so then it starts to feel more like regular civil litigation. There are aspects that are unique to condemnation, but it's still basically a plaintiff and a defendant arguing over money. That does matter, but it doesn't affect the project. The project can proceed. The project may be well over and done with by the time you get a final determination on money. Scheduling order is typically intended to be issued either at that first hearing or shortly thereafter. Scheduling order is something that exists in all civil lawsuits. There are some provisions that are unique to condemnation, but the concept of a scheduling order is what it sounds like. The court lays out the dates that will govern the case, including ultimately trial, which is when everything should be resolved in the circuit court. As indicated in this slide, one of the things that you get is a date to exchange witnesses. Witnesses typically would be basically appraisers, could be your real estate appraiser, could be a tree appraiser. Occasionally, there may be arguments about whether the project is having additional impacts on the property, such as diverting stormwater onto the property or affecting circulation of the property. You may then get an engineer as an expert in that case. But by and large, the witness list is fairly straightforward. We'll have a couple of people simply knowledgeable about the project, but the real witnesses will be the experts who evaluate the amount of just compensation. The Uniform Condemnation Procedures Act has a provision that says up to 180 days after filing suit, the property owner can come forward to us and say, you missed something. We think there's an item for which we are entitled to just compensation that was not included in your good faith offer and was not included in your declaration. An example would be if we're removing a sign, a business sign, and we don't compensate the owner for that, then it would be expected that the owner would come back within that 180 days and say, well, not only do you need to pay for the permanent right-of-way and the temporary grading, you also need to pay for the sign. That 180 days is actually a fairly long period of time for a civil lawsuit. After that 180-day period expires, the UCPA then grants an additional 90 days for the parties to exchange appraisals. Now, this 90-day period, which by definition is going to be 270 days after filing suit, requires the owner and any other interested parties who are in the litigation to give us an appraisal. That may be the first time we've seen an appraisal for them, may or may not be, but it can be. We have the option of doing an updated appraisal if we believe things have changed, if we believe that our understanding of the project has evolved, and then we need to go back and potentially offer more just compensation or potentially even less. we can have an updated appraisal, but that is discretionary on our part. We are able, if we wish, to stick with our original appraisal in which we based our good faith offer and declaration. So these dates already push you out to 270 days from the filing of the complaint. After the appraisal exchange, you still need time to complete discovery. So discovery is the information gathering process in litigation. Most of the tools are common to all civil lawsuits. You may be familiar with depositions, is where you are asked to meet in a conference room with opposing counsel and answer questions under oath. It's not a court proceeding, it's a private proceeding in an attorney's office. We can make document requests, which we would in the ordinary course, in which we say, give us everything on which you base your estimate of just compensation. We can also provide interrogatories in which we ask them under oath to spell out the facts supporting their claims for additional just compensation, and request to admit what they sound like. We can make a request, admit that this project isn't going to affect the ability to access the property, because if they are claiming that it will, then the request to admit can force the issue, and they will have to say yes or no. So those are all tools that we use to gather information in order to get ready for eventual trial. Appraisals are part of that process. They also are somewhat outside of the process of discovery. We do our appraisal even before we file suit. But again, we can do an updated appraisal after that 270-day period. So going through the discovery process, we get more information. If there's a big divide between what we have offered and estimated just compensation and what's being demanded, then discovery is a useful tool for figuring out whether or not they have a point, figuring out the evidence supporting their claim, and deciding for ourselves whether we need to reevaluate or whether we believe we got it right the first time. There will eventually come a point in civil lawsuits in the state of Michigan where you're ordered to case evaluation. Case evaluation is a process whereby 3 neutral attorneys review the plaintiff side and the defendant side in the case, and then put a number on the case. If both parties accept the number, the case is settled at that number. Up until about 3 years ago, case evaluation included as a sanction having to pay the other side's attorney's fees from the date of rejection going forward if you rejected the number. So if the panel came back and said this is worth $50,000 and we said, no, that's too much, and we rejected it, and then went to trial and a jury said, 60,000, we could be on the hook for attorney's fees from the date of rejection going forward. Now, I will say we're already by statute on the hook for attorney's fees equal to 1/3 in the increase a property owner might get. So to be clear, if we estimated just compensation is 50,000 and an owner was able to prove at trial that it's 100, then we would have to pay not only the 50,000, but we would have to pay 1/3 of that 50,000, 16,600 and change as an attorney fee for that increase. And that is often what the attorneys for owners are looking for. I mean, it's nature of the system. It's intended to incentivize them. But if we had gone through case evaluation under the old regime and rejected, there could be additional attorney's fees. Since the Michigan Supreme Court eliminated the penalty for case evaluation, it's not as effective a tool as it used to be for settling cases. So what I try to do, and most condemnation attorneys also try to do, is get the case out of case evaluation, meaning you don't have to go to that panel of 3 local attorneys, and put it to a mediator. And mediation can be court-ordered, but again, it's commonly stipulated to in lieu of case evaluation. And that's where you have a trade mediator who tries to guide the parties to settlement, typically through shuttle diplomacy. So they talk to one side, talk to the other, and try to navigate toward some midpoint between the parties' positions at the outset of mediation. It doesn't have to be smack in the middle. If it were that easy, cases would settle a lot earlier. But it's a process of weighing evidence and letting each side know that you have potential weaknesses and you need to come off whatever your position is if you want to get the case settled. So mediation is commonly the last chance to really avoid spending a lot of money and potentially going to trial. And in most of these cases, really, they should settle. The issue is not so much should they settle, it's you got to get the parties to come off of whatever their positions are and to pay more than we think we need to pay or accept less than you think you're entitled to get if you want to avoid the continued cost and uncertainty of litigation. Litigation is not a cheap process, and the prospect of potential trial is often an incentive to settle. So mediation, I'm a fan of it, and occasionally I conduct mediation as a mediator for condemnation cases because it's a fairly small pool of attorneys who do this with any regularity. And it's, it can be a hard sell to anybody to accept less than they want or to pay more than they should pay. But at the end of the day, having certainty and being able to move on and get out of court has a benefit, and most cases do settle.
Commissioner Green, do you have a question?
Yes, I do. Who's responsible for the cost of mediation, and do they also mediate the issue of attorney fees?
So in typically speaking, mediation is to be split between the
Okay.
parties. But I have commonly had mediation where an owner negotiated as part of a settlement that the agency pay the entire mediator's fee. So, but under the statute, mediation is not one of the expenses that we are required to cover. We are required to pay for the owner's appraiser. We have to pay a reasonable expert fee under the statute. The idea is that they should be made whole at the end of the process, and they're not going to be made whole unless they're reimbursed the costs that they incur to evaluate the amount of just compensation. But the answer is it should be split unless the parties reach a different agreement.
So if we're responsible for paying for the appraisal, do they also get to choose their own appraiser?
Yes. So, and you will commonly get sticker shock that someone will come back and say, we spent 15 grand in this appraisal. We weren't charged that amount. There's, probably a bit of the professionals, knowing where their bread is buttered. We have the right to say, we're not going to pay it because it's not reasonable. So it is possible to challenge an appraiser's fee if we think it wouldn't hold up. We've never done that. Occasionally, people will do it because they keep getting fees that are just really outside of what market would bear. What will happen is in mediation, you'll talk about the appraisal fee, and typically an agency will agree to pay it and waive any challenge as a condition of a global settlement. But if the number is really big, yeah, you can go into court and say, we're not paying 15, 20, 30 grand because the work, that's not a reasonable cost.
Other questions? Dan, is the clock still on the 270 days? I mean,
Well, so once you have the appraisal exchange, then you're beyond 270 days.
Okay.
You're probably going to have at least 90 days of discovery after the appraisal exchange. So it wouldn't be uncommon if we start a lawsuit today. In fact, we have started a couple last year to get a scheduling order in December of 2023, scheduling trial in April of 2025. That's what we just got. So, these types of cases where it's a roundabout and you're evaluating the just compensation for a partial permanent taking, it probably won't go to a trial in April of 2025, but if we can't reach agreement, it will. So it's a very long timeline, and it's hard coded into the statute. An owner could agree to shorten it, so we could stipulate. Usually they don't. We just put it into the scheduling order, and now you've got 16 months to litigate. Not a very efficient system, but it's the one we were given. One of the things that happens.
I'm sorry, Dan.
Just one other point, oftentimes our good faith offer monies are put into escrow. And even with this long period of time, we are responsible for paying interest on that good faith offer. So the longer it takes to get to that settlement, we're paying interest as well. So it behooves us to look at all these things, and oftentimes we're settling before going to trial.
Right, and that's true. Interest actually can become a non-trivial number the longer a case goes on. It obviously depends on how big a case it is. But the attorneys who represent property owners, they understand interest, and they will get every penny, and we're obligated to provide it. So that's another factor that weighs in favor of settlement, and it cuts both ways. I mean, owners ultimately aren't going to benefit from prolonged litigation unless there really is something at the end of it. So there's an incentive both ways, but we will be paying 1/3 of the increase in just compensation as an attorney's fee. We will be paying an expert fee, and we will be paying interest typically at the resolution of a case, because that's the nature of condemnation. One other type of event which is common to civil litigation and some parts of it are unique to condemnation, is what we call dispositive motions, sometimes called a motion for summary disposition, or in federal court, a motion for summary judgment. And that's when you go to the court and you ask the court to rule that either there are no fact issues in the case, or part of the case should be resolved by the judge, because in that part, there's no disputes that should go to the jury or to the fact finder. It's a common technique. There may be a claim from an owner that our project is, say they're claiming there's an additional impact because we're diverting stormwater onto the property. And let's say we have an expert and all sorts of proof that we're not doing that. Let's say the owner has no proof. We might then file a motion for summary disposition to take that out of the case so it doesn't go to the jury and potentially impact us in that process. And conversely, sometimes an owner will come back and challenge, for example, the credentials of our appraiser, or say there's some flaw in the appraisal and it should be excluded. That can be done through a dispositive motion or an evidentiary motion. But these are ways to seek relief from the judge as opposed to a jury based on undisputed facts, and a way to narrow issues. So if you do go to trial, hopefully it is more contained and you're not confusing a jury or confusing a judge with too many different claims. Ideally, if you're going to go to trial, you want to be arguing over the appraisal value and just have one appraiser for us, one appraiser for them, and let a jury pick a number in the middle. We may or may not win, but at least conceptually, that's easy to understand. So in the litigation process, the last step before trial is creatively called the final settlement conference. And that is what it sounds like. If we have gone through the 180 days for to identify additional items, the 90 additional days for appraisal exchange, a potential 90 additional days for discovery, mediation, and all has failed, final settlement conference is the last step before trial. We are required to have somebody with authority to settle, although in practice, we can't really do that with the board. I mean, you can perhaps give somebody some level of authority, but at the end of the day, it's understood usually by the court or practitioners that if you do reach a settlement at a final settlement conference, you still need to take it back to the board and have them approve it on the record, because it's not final until you speak. I can't bind you on issues of real property, nor can Kurt or Matt or anybody. The board has to vote on that. Final settlement conference, it's a chance to settle. Usually if you got that far, you've tried and you're getting ready for trial. But a good judge will push the issue and try to get the parties to split differences and settle and avoid trial. But assuming that doesn't work, trial. And the formality of trial is the same for condemnation as it is for any civil litigation. Again, you're dealing with something that's maybe not typical in civil litigation, the appraised value of a taking for a public project, but the process is the same. Assuming you have a jury, you're going to have to go through a process of jury selection called voir dire, where they do questionnaires, and you have an opportunity, either you or the judge, to ask them questions. For example, we would not want on a jury somebody who has been a party in a prior condemnation action, or somebody who filed suit against the road commission 5 years ago. Both attorneys have an opportunity to go through and help shape the jury to maximize the chance that it will be impartial. Attorneys didn't give their arguments. Typically, both provide an argument at the beginning of the case before there are any witnesses. And that's simply where you state, this is what the case is about. This is what we already paid. This is why we don't think any additional just compensation is required, because our appraiser is better than their appraiser, and the additional things they've identified are not compensable or not supported by the facts. The owner gets to make the contrary argument and frame the case so that the jury has an idea as to what's at stake before they start hearing witnesses. And then as in any trial, in this case, we get to go first because we are the plaintiff, although it doesn't feel like it, but we are the plaintiff. And you call your witnesses, have a chance to ask questions on what they call direct. Direct examination is you can't be leading. You're not telling the person what to say. You're just getting information out of them through non-leading questions. Cross-examination provides an opportunity for the opposing counsel to try to lead a witness into unfavorable testimony. And these types of cases, you're not going to have Perry Mason moments, but you will have the typical back and forth in which the attorneys are trying to solidify their client's position and poke holes in the other side's position, typically just on issues of just compensation. When we're done with our case, it is possible at that point to seek from the court an order saying, now that the plaintiff is done, there's nothing left to argue about because everything that was introduced in the plaintiff's case is favorable to the defendant, and therefore the defendant gets a order as a matter of law, and they don't have to put on a case. That won't happen in a condemnation case. It does happen not uncommonly in typical tort cases. If you're suing for personal injury, at the end of your case, the defendant might say, if everything that just came in is true, it's not enough, and the judge might agree. In our case, by the time you get to trial, it's pretty much inherently going to be a fact issue requiring ultimately jury deliberation and a verdict. When we're done with our most important witness being our appraiser, defendant gets to do the same thing. There is an opportunity to do rebuttal. That doesn't really matter. It doesn't come up that often, but you do have an opportunity as the plaintiff to put on a rebuttal case if something came out unexpected in the defense case. If it doesn't, closing arguments, same as opening arguments, but there you were going through the evidence that the jury has just heard, summing it up and explaining to the jury how what you just heard supports your argument in opening argument. Hopefully, it may not. If not, you're explaining why. And then the jury gets to retire, deliberate, and issue a verdict. And that's typical to any trial, any civil trial. It's going to follow that process. And with condemnation, again, what is unique is you're asking a jury to opine on something that's really a subject of expert testimony. This is an issue for a judge too. And Commissioner McCollum's question is a good one. There may be some judges I would prefer over a jury. I think actually it probably is worth making an individual assessment after a case has been assigned as to whether you want that judge or a jury. But as a rule, we give it to a jury, and you run into this problem, which is just inherent in our legal system, is you're asking a group of lay people to weigh in on what is commonly an expert question. But through trial and error over the centuries, we have concluded that that's better than any other system. And I do believe that there is at least something refreshing in having actually a jury of your peers weigh in on what your legal rights and obligations are. But
Let me stop you just a minute. Any questions, Commissioner Green?
Does a jury have the authority to expand or restrict the attorney fee?
no,
No.
no. In fact, what you're going to have under, at least assuming the jury instruction, there's something called model jury instructions. And these are instructions that have been crafted up in Lansing by the state bar and committees, and they are intended to be used in all condemnation cases. You can request additional instructions specific to something unique about your case, but under those standard jury instructions, the jury is going to decide additional just compensation. And when that is done, the verdict actually doesn't end the case, because now you got to calculate the attorney's fee, which is 1/3 of the increase in just compensation, and the interest and the expert fee. Those things probably should just be issues of arithmetic, but you could have a dispute, potentially. But the jury will not do that, and they don't have the ability to curtail the fee. I really, to be frank, I doubt the court does as well. But if you had a basis for saying that, then it would be for the judge to decide.
Questions? I just have one, Dan. When you remarked that you have no authority to make a determination about the final just compensation amount, do I remember correctly that this board has on occasion given you a range
It
not
has.
to exceed? And in that case, are you empowered?
Yes. So this is actually raises some really interesting procedural questions. I get that authority in closed session.
Right.
So it's not public record, but I know what you said to me, and there should be minutes that are not public,
Right.
which say what authority I was given. And I have gone and settled the case pursuant to that authority. We're still going to bring it back and put it on the record and have a vote.
Okay.
Now, I don't think the board could change its mind at that point. But that being said, up until that point, there is no public record that you've approved this, that it was authorized. But yes, that can be done. And in fact, it's an important tool for us to come in and say, look, this is where we think it's going. If you give us this authority, we'll try to get it done and come back and ratify it with you. But it is, it's not really done until it's on the record, which requires coming back to this board and having you at least ratify what you previously said would be acceptable in closed session. But if we don't have that authority, then you'll be in mediation or in a final settlement conference. And at that point, I'm there, Kurt's there, maybe somebody else, and we're saying, well, we think we can do this. We think the board will agree to this, but we don't know for sure. We don't know for sure. So if you reach an agreement, you got to take it back. And we have to convince you in closed session that this is the best resolution for the road commission, and for our public purpose.
All right.
Well, as with everything in the law, it doesn't end here. There's always another layer, and that would be appeal. In every civil case, when you get to a final judgment, each party has the right to appeal if they are dissatisfied by filing a claim of appeal within 21 days. Starts a brand new process, which itself gets stretched out 1 year, possibly 2 years or more. Inviting the Michigan Court of Appeals to review the case and rule on whether there was error. There's an uphill battle if you lost and there's a jury verdict that was entered against you. The trial court's decisions on what type of evidence to admit, things like that are discretionary. So you have to get the Court of Appeals to believe that there was an abuse of discretion. You could, if the trial court let the owner sort of talk about things that should not be compensable, if the owner said that, I don't like looking at construction vehicles, you should pay me for that. And if a court allowed that argument to a jury, then that would be an appealable issue because that's not compensable. That might be an example of the type of thing where you don't like what happened in the trial court and you're seeking review by the Court of Appeals. Again, it's an uphill battle. We've had a couple of appeals, but by and large, the cases are going to resolve themselves as a rule before you get that far. At least most of ours are. We don't really have cases that are like 7 figures. It's not the nature of what we do. When you get to cases like that, and you had a few, for example, with the Gordie Howe Bridge, yeah, you might find, quite a lot of really proper litigation because the amounts at issue are so high.
Commissioner Green, I'm sorry.
Madam Chair, so if an owner is dissatisfied with the verdict and they appeal, and we know that appeals cost money, who's responsible for the increase in cost? Are we on the hook for that?
No. So ultimately, we're only going to be paying 1/3 of any increase in just compensation. So if the owner is dissatisfied and they file an appeal and they lose, then that's on their dime. We're not required to pay anything. If they win, typically it's going to be sent back down and there will be another trial and they're only going to be compensated for the appeal and the trial on remand if they improve their position. And again, it's capped. There's a practical reality that if you're talking about, we think it's 25,000, they think it's 50,000, there's not a lot of incentive for us or for plaintiff's counsel or owner's counsel to really litigate hard. At the end of the day, I'm not sure how happy you would be if I succeeded in getting you 25 grand instead of 50 and then gave you a bill for 75 grand to get there. So in these types of cases, you have to consider cost because that can be a significant percentage of the amounts in dispute. There are competing concerns. One is that we do evaluate in good faith what we think the value of the property taken is. We don't want to pay more than that because that, these are just public monies and we just can't give money to people simply because they ask for it. Flip side is we also don't want to run up cost that begin to exceed the amounts in dispute. So you just have to draw a balance between what we're willing to consider when the owner makes an argument for more just compensation in light of what it might cost, but also versus our duty to be conservative with public monies.
We're good.
Any more questions?
Is it Commissioner McCollum? Oh, no, I was wondering, I know we have one more page, right?
Oh,
That we
well,
did.
you are right. And this is just to put into visual perspective the process. So this is an actual project, Pontiac 7 Mile. You might remember a few years ago. We did have to file a condemnation action against the owner of the northwest quadrant. There were some disputes, and this is not an uncommon claim. If you can see how we have the island going north on Pontiac, if I got this oriented correctly. And one of the claims is that's going to impact the ability for traffic to get to the property once it's developed. So there was an argument that although this was a large parcel, only that little corner that we're looking at was actually buildable, and that by putting in this roundabout with these traffic islands, we were diminishing the ability of future anticipated commercial traffic to get to the property. We didn't really buy that, and the project, we think, accounted for future development uses of that property, but it's the type of thing that gets argued over, and you'll get an appraiser coming in and saying, well, actually, there is an impact. They do that by referring to comparable projects in other counties or other townships, and we'll push back and say, well, actually, if you look at these other comparables, there's no impact. This is one where, pretty classic case, the spread in what we thought was just compensation versus what was demanded wasn't really that large. And before getting into significant expense of discovery, we mediated a case. Interestingly, mediation did not settle this case, but then we case evaluated back when there was a penalty, and case evaluation did settle the case. So that was a number that both sides could accept. So it worked out well. But going back to what might be the key takeaway from this, the important thing for this project and this condemnation proceeding was that we established early on that we had the right of way. And then after that, we have the luxury of time in determining whether we offered sufficient just compensation. And most experienced condemnation attorneys for owners aren't going to fight on necessity. It's really not much of an upside to the owner or to the attorney to file such a challenge. Typically, they will agree and allow us to go forward with the project and simply argue that the impact was greater than we had estimated. That's how it worked out here. The project was allowed to proceed. It worked out well, as I understand it. That was a bit of a problem intersection. So this is one of these cases where the system worked and we were ultimately able to settle. But had we not settled, then we would have tried the case, and the risk wasn't that great. I mean, I don't mean to diminish having to spend an extra 20, 30 grand plus additional attorney's fees and expert fees, but it's to some degree cost of doing business for us. We simply have to accept that we have to do our best, and sometimes that isn't good enough, that we'll be required to pay more.
And then I think we have another slide where we're going to summarize.
Commissioner McCollum, did you have a question?
I had a question about the Uniform Condemnation Procedures Act 87 and 1980. So I looked it up, and it's pretty self-explanatory. But then on the history, it says, I don't know why it calls it history, because it's after 1980, but it says 1988, Act 189, July 1st, 1988. I'm wondering, was there something added, or can someone do something to circumvent this act?
So short answer is all condemnation, at least that we do, proceeds under the Uniform Condemnation Procedures Act. It just always does, because we get to decide by filing the lawsuit under that act. There are acts that predate the Uniform Condemnation Procedures Act, and it is still theoretically possible for us to follow another avenue for condemnation, but we don't do it, nor does any other road commission. The history you're referring to is an act will be enacted and adopted, signed by the governor, and then over time there will be changes. Now, I don't know what that specific change was, but I'll give you an example. There was one change in the last couple of decades to deal with what they call general effects. If you are having a part of your property taken for road right of way, can you say, in addition to the cost, I want compensation for the dust, the vibrations, things of that nature, or the increased traffic, or what have you? Now, the law is very uncertain of this. People will say, for example, you should reimburse me for my lost business because my business was curtailed or shut down while this project was going in, and there's some division as to when and under what circumstances you can recover for that type of damage. But for general effects that are suffered by the public at large, that was written into the Condemnation Act to deal with case law that had started to become a little more rewarding of owners. So the legislature is drawing a balance between what we have to pay in just compensation versus potentially prohibiting windfalls from owners who, in the example I'm giving, they're just, construction is a bit of a nuisance in general, but we wouldn't have roads without it. And so the legislature has judged that, well, just because you're complaining like everybody else about the inconveniences of construction, that in and of itself isn't going to give you basis for additional compensation. So that would be an example of an amendment. But the history you're referring to starts with 1980 because that's when the Public Act was adopted. And then it will note that there have been changes. And if you want to know what actually happened, you got to go back through the legislative history to figure it out. It's actually not easy. I mean, that pretty much everything in the law is more complicated than it should be.
Thank you.
Any more questions? So I kind of did a summary. Do you want me to do a quick wrap up?
Sure. Thank you.
So
You've got 4 minutes.
4 minutes, good. Well, it worked out well.
Council.
And now I feel like I'm in.
You can follow the slides. There's a couple.
Feel like I'm in the Court of Appeals
There you
now.
go.
All right, so hopefully your needs for right of way don't get to me. It is Kurt's job, and Kurt is good, and 95% of the time, he's going to go out, get what he needs in terms of an easement or a license in order for the project to proceed. I don't have to get involved. But if I do get involved, usually it's pretty much by design, a near emergency, because as Brent was talking about, you work backwards on your project to when you need your right-of-way certification, but you can't seek that certification without actually having plans drawn up and potentially even a survey. So you have to do a certain amount of work to be able to state what it is you want to take. And by that point, you're coming up on a project deadline where you might miss a calendar year if you don't go ahead and certify right away and be able to hit your bid window. So that's why at the beginning of these cases, we're always pushing fairly hard to get the order for possession. And once that happens, it's into a situation of attorneys arguing about money, which for the most part they do through appraisers. And that gets us into all we talked about in terms of the appraisal exchange, the omitted items for appraisal, discovery, mediation, case evaluation, settlement conferences, and ultimately trial. That's a process where I'll report to typically to Kurt, Matt, or whoever wants to be on these email strings, I'll report to. But it's to a significant degree going to be invisible to you, except for when big issues come up where we have to make decisions of whether to settle. So then it's just like any other litigation. And I'll, I've never had to try one of these cases. I've had to try other types of cases, but for the most part, these condemnation cases will eventually reach settlement. And that's been the case so far for us, knock on wood.
If you can go to the next slide, and I think that's a nice summary there. Ultimately, you have to weigh the cost of a trial and the cost of settlement, and that's and what benefit is there for the public? Because trials are very costly. And in the history, for me, I don't think but one time did we get to a trial point for a right-of-way condemnation.
Right, and I did have to do an evidentiary hearing on necessity, which is a sort of a type of trial. But in terms of taking just the issue of the appraised value of the taking to a jury trial, I haven't had to do it for the road commission. I've had to do this in other types of cases. So there is a trade-off here. You could always justify early on throwing money at an owner to make them go away. But that's really not the message we want to send. We don't want to pay money unless there's been a showing made that what we already offered is inadequate. It just isn't good practice. It isn't good use of public funds to simply award money to somebody because they asked for it. So this is partly what drives the process. So you'll get a demand that isn't really grounded in reality. And yeah, we could rationally pay it, but now we are setting a precedent and a practice that is certainly going to get out among condemnation attorneys, and we're going to find ourselves facing more extreme and more intransigent demands in the future. So we have to look at things through the lens of what is the just compensation for this property. If we can be convinced that what we already offered is inadequate, or at least there are shades of gray here, then we could have that conversation. And in that process, we can consider avoiding the cost and uncertainty of trial. But we really have to go through a process of creating a record documenting that what we are proposing to pay, if it's an increase, is warranted either by the facts or at least by a good faith interpretation of the facts.
One final question.
One
Commissioner
final
Green.
question. Does your office get involved in the initial good faith offer?
So generally, no. Kurt and I will communicate if he thinks something is going to go to trial. And occasionally he and I have communicated about, how do we formulate a good faith offer, because there might be something in it that could create an issue. if we wind up in court. But only in those cases where the writing's on the wall, we are confident it's going to go to trial, would I be given a heads up? And even then, it's really more just, you should know this is coming down the pike. But it's mostly staff, and most of the time, it doesn't even get to me, which is to their credit.
All set. Thank you.
Thank you. I
Danny.
appreciate you having me
Happy
come
New
in.
Year. Good to see you.
Happy New Year to all of you.
Thank you.
We're scheduled to take a little break here. Is that all right?
Absolutely, Chair.
Okay. Okay. So we are scheduled to come back in at 10:55. If we're back before then, we'll commence. Take a break, stand up,
Thank
stretch
you.
your legs, see if your hips. Welcome back, everybody. We are continuing with our working session, and the next, well, I'll turn it over to our managing director. You can set the tone for us here.
Thank you, Chair. The next agenda item is our permits overview. And with us today, we have Brent Schlack, Director of Engineering, and Mark McCullough, our Senior Project Manager of Permits.
Good morning. I think it's still morning.
Yes.
Brent Schlack, Director of Engineering. I'm quickly gonna bring up Mark, but I just wanted to, Mark McCullough, he's our Senior Project Manager over permits. He's been here coming up on his 25th year with the Road Commission. The last 5 have been with permits. So he's worked within traffic and safety, within project development, our design, and now, at one point, we had a subdivision group within our that laid out within our engineering department, and he oversaw that. So he has a wealth of knowledge, and he's overseeing our permits now. And so I'll introduce Mark and bring Mark up. You can introduce yourself.
Thank you, Brent.
Yep.
Morning, board.
Morning.
How are y'all doing?
Good. How are you?
Doing well.
Identify yourself for the recording, please.
Mark McCullough, Senior Project Manager for the Washtenaw County Road Commission, here to give you an overview of what we do on a daily basis in permits. It's a broad conversation here, but at any point along the way, you have questions, you're more than welcome to stop me and ask, and I'll do the best I can to answer your questions so that you have a little bit better understanding of how we do business here. So here's an overview of the PowerPoint presentation here. I'll introduce the permits team. We'll go into some background information. We'll talk about the application process, and then we'll do breakdowns into categories, the transportation permits, which is our trucks, the heavy trucks that are on our roadways that require permitting. And we'll get into the other side of permitting, which is the right of way. Those are the utilities, the driveways, the commercial aspects of that happen within the public right of way. And then we'll get into what we do once we issue the permit from there to close out. All right, so first we'll do an introduction of the permits team. There's 6 of us, not including me on the team. Callie Lawrence is our permits clerk. She is the face of the permits team. She answers the phones. She's the first person they see in the lobby. So she really sets the tone for the public when they either call, send an email to the general permits number or email address, or stop in. So she receives the applications and takes payments. She answers lots of questions. She does account oversight. So she'll make sure that if the permit's being issued, that they have their liability insurance, do they have securities and their finances. And we'll get into that, what those 3 things mean a little bit later. Then we have our utility coordinators, permit coordinators, but primarily utility coordinators. Getting ahead of myself. So Lauren Purdy and Lisa Jones, they've been in their roles for 3 and 2 years respectively. They review residential driveway approaches. They review the utility applications that come in. So the AT&Ts, underground or overhead, DT electric. And then we have this miscellaneous stuff. So anyone that wants to come in and do drainage improvements along their side of the road there in front of their house, that would be considered a miscellaneous activity. So once the application is submitted, it gets handed over to these two ladies. If it's in their respective areas. So they provide guidance to the applicant, they see it to issuance, and then they do the field management once the permits are issued. And we have our two inspectors, our technicians, Larry Plezowitz, who's been here for near 30 years now. And Josh Jacobs, who's been here on and off, but in permits for going on 3 years now,
How long has Larry been in permits?
30.
What I thought you said.
It's been a while. So they play two roles. They are our waymasters during seasonal weight restrictions. That's the uniform Larry is wearing, the brown uniform with the badge on it. And then they also do site inspections throughout the year when it comes to any type of a permit application, primarily commercial. So if someone has a question about inspection, needs guidance, one of those two people will be out and about driving around, get a phone call, they meet them on site and then give the guidance or does the routine checkup to make sure everything's going okay.
Ask a
Commissioner
question.
Green.
Yes, sir.
Does Larry's badge mean that he has the authority to issue citations?
Well, it depends. If it's involving the Michigan Vehicle Code for trucks, yes. But that's pretty much his limit, nothing else. For instance, like speeding or stuff like
Yeah,
that,
yeah.
we don't really get into.
Weight restrictions.
Weight restrictions, that's correct. Okay, and then there's my mugshot on the left, and then Gary Straight. Gary's been with us since circa 2005. He's been in permits since at that time when he came over from the city of Troy. So the two of us primarily review plan reviews, and we'll get into what we call traffic impact study, road improvement agreement, should it come to fruition, and then we get into how we manage the projects. All right, so that's the team here. So we'll go into the background. So I like to think that we have in permits three purposes, primary purposes. We have more, but the three purposes are protect the road system. And by protection, we mean making sure that the assets are not being subjected to hazards or stuff that would make it affect its integrity. So whether it be seasonal weight restrictions would be one, but also during construction, are they doing the right applications with their equipment, making sure that they're not affecting the roadway in general. So we want to make sure that when they do work in the right of way, we're having our assets protected. We want to make it sure that it's safe and convenient for the motoring public, and it really all users, not just motoring public, but any walkers, bikers. And then manage third-party activities to ensure that it's being used and accordingly to the permits, procedures, and regulations as passed by this board. Okay. So we take teamwork and customer service very seriously in permits. There are a lot of moving parts. There's a lot of communication that needs to happen, whether it's up or down, up to the board, to the townships, and then laterally to the operations side, engineering, and then administration, making sure they're in the know, whether it's stuff that's high level or just keeping them in touch with things that might come their way. Should anyone ask them a question, mostly a township supervisor, but sometimes you guys get a call from the public or from a township board member, and then you relay it, and then Matt has the answer, Brent has the answer. So we try to keep them in the loop as much as possible. So we try to keep that a two-way street so that over communication is a good thing. That way we make sure we cover our bases and making sure that we're not overlooking aspects of our jobs. The guidance that we use is the procedures and regulations that was as passed by this board on May 18th, 2021. It has different sections in it, 8 in particular, and it gets into driveways, utilities, how to issue a permit, any types of conditions that go along with it, construction. So it's transportation, so that it goes into each section, but by and large, I like the document. I think it's well written. I inherited it from Jim Harmon. Then from 2021, I took it from there just to modernize it because it was at that point going on 15 years old, and just making sure that it's up to date. So it's a good document, and it continues to be a good working document for us.
Mark, is that on our website, I assume?
It is on our website. It's another permits banner.
Okay, thank you.
All right, so we'll start with the application process. So that starts with Callie. So all this information you can see are screenshots from online from our website. This is what a user would see on the website under the permits tab. So we have permit applications, and then there's 3 boxes that they can check. So there's the right-of-way applications, there's the transportation applications, which goes to our ox cart system, which we'll talk about that party system in a minute. And then there's advanced notice of work. So basically, we want, once we issue a permit to a permit holder, we want them to inform us when they're going to be working within the road right away. That's what that outer right box represents. So within the right-of-way permits, there's 4 different selections that an applicant can choose from. We have the commercial, which we'll get into all 4 of these things in a moment here: residential, utilities, and right-of-way. So they will click on that. We try to give a brief description underneath what it is, so that they submit the appropriate application. Okay, once the application is submitted to the road commission, it's checked by Callie, and everything looks good, she'll send a payment request for application fees. And the fee is dependent upon what type of application it is. So we send that via Venmo, so that gives the applicant an opportunity to do it electronically via credit card. They are welcome to submit a check if they'd like. They can also come in, pay if they want to. So they have an array of options, but by and large, PayPal, Venmo is the way that people prefer to do business with us.
I have a question.
I'm sorry, Commissioner
ma'am.
Yamas.
So they can pay with credit card too. So there's 3 methods besides the old fashioned write a check, correct? Credit card, Venmo, PayPal. Okay. Thank you.
All right, so there's, like we were talking about, and there's 2 different sides to permits. We have our transportation permits, which are the special moves, overweight or oversized vehicles, and then we have the right-of-way. So that's the driveways, utilities, development, and miscellaneous. So starting with the transportation permits, these are the typical types of applications that we see for people that are using our ox cart system, which is primarily used in Illinois and Michigan, and it's expanding to other states rapidly, where it gives each person that wants to do business in the public right of way by carrying loads that exceed axle limits per the Michigan Vehicle Code, an opportunity to submit rapidly, and then usually within 24 hours have their permit ready to be able to transport whatever piece of equipment or goods they want to. We've heard great things about it from the public at large. They think this is great. Time is money to them. Matt McDonnell actually instituted, he was the first, we were the first, one of 2 actually, from my understanding. What do you think, it was about 8 years ago, Matt?
Yeah, it was several years ago. Oxcart was the online system. One of the big benefits was it's one-stop shopping, because if multiple jurisdictions are on the route, they can go to Oxcart and easily apply for various road commissions or cities that are in the Oxcart system. So we were one of the first in the state, and it's worked out really well.
Yeah, it was a chance we took, and Matt saw the future, and it was a gamble we're taking. It's great. People followed our lead since then, and I have nothing but great things to say about it.
Do we subscribe to that? Or is that
So it's an
supported by people who apply?
Yeah, so it's an online system, as the great question. We don't pay anything for the service that it provides. The model that they have chosen to go with is that the users pay a fee.
Okay.
So if our permit fee was $100, it might be cost the user $105. And then that's how they pay for their online system.
Interesting.
And they have no quarrels about it, because they said time is money. We were happy to pay this small fee to Oxcart in order to get our permit to us quickly and expedited.
So who doesn't participate in Oxcart? I'm thinking of someone trying to move something.
MDOT currently does not. They have their own system.
Okay. Just an idea.
Great question.
It just seems like such a smart way to go.
It would be nice, but there's differences in opinion, and we'll see if those ever get worked out.
Okay.
All right. So contractors mobilizing heavy equipment like you see here to a job site is one reason for submitting an application. Manufactured housing, so it comes in two halves. Those are oversized. So it's not that they're heavy, they're just oversized that require them to have a special permit. You have the public utilities that are really overweight. So the more wheels you start seeing axles you see closer together, that just indicates the more weight that they're carrying. So they will require a special permit. Our gravel haulers that we hear a lot about, we have a lot of mines here in Washtenaw County that supply aggregate and sands to places both inside and outside of Washtenaw County. So this gravel hauler in particular is over length and usually is overweight, so hence they do require permits. Then you have your miscellaneous. Sometimes you see these going through the county to put up a wind farm up in Lenawee, Jackson, someplace out in that area, sometimes in the Thumb. Yes, ma'am.
Yes, I wanted to know, in issuing these reports for oversized loads on the roads, and that causes perhaps more wear and tear on the roads. So does this, putting in for the permit, paying for the permit, does that help pay for maintenance of the road that they're
Yes.
overweight on?
So hence the idea is that, all right, we know that they're going to have an effect. To what degrees? By itself small, but in combination large. So every time they apply for a permit, that funds goes into our general system, which then can be used to go for a chip seal. I don't know exactly how Matt and Brent worked that, but those permit fees go into the general fund.
Yeah, so our permit application fees cover our costs for our staff to review them by and large. There are a fee schedule that when we adopted our current procedures and regulation for permit activities, we also adopted, this board also adopted our fee schedule. So the fee schedule typically is reimbursing for our costs, but oftentimes our average cost is pretty minimal time because of the ox cart system. So if it was $100 fee, if our actual cost was roughly $75, that extra 25 would go into our general fund and we'd have the ability to invest into the infrastructure. So not much, but there is some. And keep in mind, a lot of these are just oversized loads that are over width or over height. And so there isn't a large impact on the infrastructure. It's the really heavy ones, but we don't have a way of recouping the cost of the damage to the road. Obviously, commerce is going to happen, and part of providing a good transportation network, we're going to have these legal limits, and really Lansing sets the legal limits for the trucking industry. And then we're just a regulatory agency making sure they're abiding by the law.
Thank you.
Yes, ma'am.
Did you have a question?
Yes.
Please.
Yes, sir.
So double trailers are allowed in Michigan, but triple trailers are not, right? Is that accurate?
Correct.
Okay.
What was it?
Triple trailers are not.
Truck trailers are not allowed, correct?
Okay.
Are there exemptions for agricultural uses?
There are. I couldn't tell you what they are because our waymasters get into the nitty gritty on
Okay.
that, but there are exemptions for that.
Yeah, I think commercial trucking, there are a lot of nuances in the law. And one of them, keep in mind, we're only permitting the loads that you see on our county system. We're not permitting things that are in the interstate. We're only permitting things that are using our road network, not inside the city of Ann Arbor, not on the freeway system in Washtenaw County, just our road network. And so there are limitations on how long you can be on a county road, a local county road. So that's really what we're permitting is that additional length or additional weight.
So if they go through different jurisdictions, it's upon the applicant to get additional permits as needed to the appropriate jurisdictions. There was talk about uniformity across the entire state, like one shop, a great in principle, but I don't know how that's gonna work out, but
So that's not what Oxcart is.
no. I mean, Oxcart has the ability to do that if that's the direction the state of Michigan wants to go. But right now, Oxcart gives each individual jurisdiction the opportunity to issue a permit for.
Through them.
Mhm.
Other questions?
I did.
Oh,
uh,
I'm sorry.
Yeah, go ahead.
Yamas?
I was, when you were talking about Oxcart and it can only go over our roads, does it connect with the city roads? It does not, or the township roads?
Anything within the township would be our jurisdiction. Anything inside the city limits is the city's jurisdiction.
Thank you.
No problem.
Okay. So those are give you a picture of what the different types of application processes are, or as far as the transports. This is our truck operators map. It is online. It is a key to each individual that's applying for a permit as to what route they should take to get to their point of destination. The blue routes are, yeah, it's hard to see on here. Of course, I only had so much to be able to
I understand.
put on there, but the blue routes are what we call our all-season roadways, so Old 12, Jackson, Plymouth Road. So those give the applicant the ability to haul heavier throughout the year. But the ones that you see that are not blue, those have to follow lighter loads as prescribed by the Michigan Vehicle Code, typically 18,000 pounds per axle. The green are the township imposed no trucks. We really don't get into that. That's something that we defer to the township, so we don't police those matters. We'll advise them that they can't use that route, but we're not out there making sure that they're sticking to a different route and basically trying to. We're not doing enforcement, as Matt would say.
Commissioner McCollum,
Yes, so I'm looking at my neighborhood on here.
which is, Mark
it's-
doesn't know where you live.
Oh, I'm sorry.
West Willow.
He does know where I live.
Okay.
Okay, in that, that diamond area. Oh, I think I see so, we're right next to the expressway. And we're not supposed to have the trucks come in our neighborhood. I don't see green over there. Is it because it's not enlarged or?
Correct. So Ypsilanti Township, to my knowledge, does not have any township restricted roadways. They might have some actually in the one corner of the county. But otherwise, I'd have to look into that. So I'm just gonna give you a runaround answer. I don't know specifically. I'm not aware of any in your neighborhood.
I can speak to that. The road commission does have a restriction, I believe, on Tyler DeSoto, but we'll look into that and get you that resolution if there is one. So the purple routes, and I'm sure Mark's gonna get to this, are restrictions that the road commission has put in place for
I was
no
just gonna
through
get into
trucks.
that next.
Okay.
So there might be some road commission restrictions, so you might not see the green, but there may be a purple road. Very difficult to see because of the map is for the entire county.
Yeah.
But we'll, after the meeting, we can look at that together.
Thank you.
Gloria, did you have a question?
Yeah, I did.
I
It
thought I
was
saw
a-
your hand.
Yeah, the purple roads are also, it can't read it. Is it WCRC restricted roads?
Correct. This board passed a resolution once upon a time, a traffic control order, restricting the use of commercial truck unless it's getting to a point of destination along that route. So they can't pass through there. So that would be a route that we would enforce as part of our Waymaster duties.
Okay, so that kind of was my question, how those are the roads that are enforceable that our workers are on.
Commissioner Green,
And is there such a thing as an emergency route?
So those are primarily along just off as an alternative for the state trunk line system.
Mhm.
And I've never dealt with one personally,
Okay.
but my suspicion is that, and Matt, correct me if I'm wrong, that MDOT works closely with each jurisdiction to utilize, say, an all-season roadway such as the Blue Road. Old 12 Jackson would be an example where that would be an applicable alternative route should there be some type of incident along Interstate 94.
I see. Thank you.
Yeah, it may not be designated an emergency route. There's a special designation. But oftentimes, before the freeway system was, constructed, you can see the bulk of our blue designated roads are paralleling the interstate system. So you can see Jackson Road parallels 94, Whitmore Lake parallels 23 north of the city, east of the city, M14 parallels Plymouth Road, and south of the city of Ann Arbor, you have Carpenter Road paralleling US 23. Oftentimes, if there's an incident on any of those interchange or freeway systems, they'll get off the interchange, the closest interchange, and they'll use the local designated county roads. They may not be signed as an emergency route, but they're definitely used in that manner.
And once upon a time, those are MDOT roads that just got turned over to the road commission, 50s and 60s primarily.
Commissioner McCollum.
Yes, I do see a purple line going through Tyler, going down that one street to Tyler. So if we see a truck and we know it's a purple designated route, what do you do? Do you contact someone or?
Absolutely. So you can let us know through myself or Mark, and we will have a weighmaster take a look. But keep in mind, they are allowed to make deliveries on that road. They just can't go through.
Oh. Well, I wouldn't
No
think,
through
these are like
trucks.
big trucks, like.
Yep. And ultimately, a weighmaster would have to be out there to cite them for that. So if we get reoccurring complaints,
Mhm.
we'll send a weighmaster to do some commercial vehicle enforcement.
Thank you.
It happens on Earhart Road quite a bit. We, from Ann Arbor Township, people are suspecting certain overweight vehicles. We've checked it multiple times and the tickets come out to the point they're in compliance with state law.
Yeah, you can get the complaint of they're on a no-through truck road, or the gravel haulers are too heavy, and so they'll pull them over, look at the ticket, the weight ticket that from the plant, and they know they can calculate whether it's too much or not, or they can physically weigh them up with their scales.
Question, do I remember that York Township rescinded its no-through truck route designations under, that I think under Joe Zarowski they were instituted, but I thought I remember that they lifted those.
They lifted them on portions of certain primary roads.
Okay.
Now, this map may be old because I used it for a presentation 2 years ago, but yes, to Matt, what Matt
I
said.
don't remember when they.
Yeah, current maps on the website as well.
Okay.
Okay. So the Oxcart system, this is what an applicant would see when they log into their Oxcart account online. They create their own unique identification. And within it that they would input in this data that's requested to be as part of the permit process, the year, make, and model of their truck, number of units, their license, and then getting into as far as how much they're going to weigh. In 2023, we issued 2,193 permits, and the application fees totaled just over $177,000.
That's for Washtenaw County.
Just for our Washtenaw County,
Thank you.
just for our jurisdiction.
And that goes into the general fund? It's not earmarked in any way?
We received it in under our permits fees. And then, yes, it goes into the general fund. And again, the intention is to offset our labor costs for our staff in permits.
Okay, so then we're going to transition now into the public right of way. So we had the trucking aspect of it, what we call the transportation, and these are the four pillars of what I'll call the right of way permits. So by and large, this pie chart this is from last year. Orange represents utility, which was 62% of the applications that were received. Residential driveways were 17%. Commercial driveway approaches or some type of work associated with commercial was 12% of the applications. And then just whatever was left, the miscellaneous was 9%. So this keeps us busy throughout the year. I mean, yes, construction season is busier than other times, but even in the winter, people are starting to think ahead to the next year. So this is pretty much a 12-month process that keeps us, keeping us busy. Yes, sir.
Commissioner Green.
Thank you. So I thought that residential driveways were under the province of the township.
No, I mean, I guess elaborate. What do you mean by that, sir? What was the impression that you had?
Like in my township, which is Superior Township, I go to the road commission as opposed to my township for a right-of-way permit.
For a driveway permit?
Yes.
Yeah,
Yes.
the township would, as part of the building process, would refer you to, any township would refer you to the road commission to make sure that you have legal access to the road right of way.
Okay.
So yes, the road commission is solely responsible for that ingress egress to the public road right of way.
The other part of the puzzle is when you're building a home, oftentimes the township is issuing the building permit.
Right.
So they won't issue a building permit until they see a driveway permit. So that's that cooperation slide that Mark had on there. We're always working lock and step with the township. So oftentimes there'll be a home builder. They will make sure and secure the driveway permit first. Then they'll go and secure the building permit to build the home. There also might be a soil erosion and sediment control permit as well. So that applicant was responsible for all the permits, but usually the driveway permit starts first. And there's a good reason for that, because we would need, and Mark will get into it here shortly, to look at site distance and where that driveway location is relative to the property.
Thank you.
Commissioner McCollum.
Yeah, I'm a little confused about like the commercial permits, like the different companies for Wi-Fi and all of that. Is that under that, like AT&T and those people? Is that commercial?
So that would be utility that you're referring to. So commercial would be like, let's just say Lowe's, Meyer came to town and they wanted to build a brand new store.
Oh.
So that would fall under the commercial application process, because lots of times they have a bigger impact on the public road right away than say John and Jane Smith would have to put a residential driveway to the public road. Any type of occurrences that happen related to that building, so to provide internet to that would be a separate permit under utility. So whether it be gas, electric, fiber, those would be separate permits that would fall into the orange category. But it first starts with the red. In that case, the application has to come in through commercial for it to be approved by the township or the road commission and other various jurisdictions. And then once that's done, then they hire the appropriate utility company to then service their new location.
So if someone, if a company started putting in, using the right of way to put in their fiber, whatever, and they didn't go through the township for the to get the permit, we had that issue in Ipsy Township. They would show up and start working, and then we found out they didn't have a permit.
So
Yes, go ahead, Matt.
yeah, I can just speak to that one. So utility companies, they don't necessarily need permits from the township to do the work in the road right of way. Oftentimes they're notifying the township that the work is occurring. That's the desire, because the township officials oftentimes are the first phone call residents make to, hey, someone's tearing up my yard, what's going on? But I think making sure we have good communication with the townships. We put out a weekly road update, but unfortunately for us, we may issue permits, but they're responsible for notifying us when they're going to work in the public road right away. That doesn't oftentimes always occur. So we're never knowing the timetable when that work's going to occur, only that it's been permitted and The utility companies also have what's called a blanket permit. So they have a blanket permit to perform work. And it's very specific on what they can do under the blanket. And that's another one, I don't think we speak to in this
I didn't get into. that part.
presentation. That's pretty into the weeds. But we can talk about that if there's questions on blanket activity. A good, for instance, would be if there was a down pole, DTE has the ability under the blanket to go replace that pole, that single pole. If it was 100 poles, we would want to see a unique utility permit. So that would be an example of what the blanket could do. Or if AT&T needed to access a pedestal for service, that would be considered on the blanket. If they were going to run a new fiber optic line and put in multiple pedestals, that would be a unique utility permit.
Thanks for clearing that up.
No problem.
And it's not infrequent for us to receive a call from the township asking about something that's going on. Sometimes we know about it, sometimes we don't. Upon investigation, Ypsilanti Township's a good example where a lot of the work occurs in its own easement out of the right of way. So we wouldn't get that notification.
Okay, okay.
But sometimes that's a combination of the two. AT&T is someone that we've had conversation with in the past. They've done much better moving forward with notifications. So we're happy with that turnaround, and hopefully moving forward, we have less and less incidents like that.
Good, thanks.
Mhm. So we'll start with residential driveway approaches. So this is the first pillar. So person wants to build a home in their, I'll use that example. There's other examples, but that's the most common one. Want to build a house and it doesn't have a identified driveway to the public road right of way. They would need to submit an application with a desired location to where they want to gain access to the road right of way. And then from there, we would go out there and measure what we call site distance to make sure that depending upon the speed and conditions of the roadway, they have enough clear vision for a car to come in and out without being a hazard to someone else using the roadway. So depending upon what type of application it is, residential would be a 10-foot offset. We don't need to get too deep in the weeds on this, but this is just a graphic that I thought that made the most sense here, where you go from, for residential, 10-foot off, and then you go so many feet to the left and right, you calculate how much you can see to a certain point, having being 3.5 feet above the ground at both points, and then measure that, and then it falls within the minimum site distance requirements based on the speed of the roadway. It passes, and then we would likely move on to the next process to issue a permit for the residential driveway. I got a couple pictures here to kind of do a demonstration. So there's 3 types of issues that we come into with site distance. One is the road alignment, the hill crest, the hill and the valleys and the tops, the peaks. That can be problematic in certain parts of the county where a car gets lost behind the other side of the curve coming in at them. And then depending upon the speed limit, it can also be problematic. Trees or roadside brush is another issue that residential applicants run into when applying for site distance. And then what we call roadside berms. So just over the course of time, whether man-made or through the glacier process, there is restrictions along the roadside from earth that may or may not need to be moved in order to have a permit issued. So this is Lauren Purdy. She is our permit coordinator. She is calculating the site distance for a residential driveway. That's called our target. So it's 10 foot measured from the edge of the gravel road there. She's making sure that's 3.5 feet above where she's standing, not necessarily where the target is standing. And then she'll get into her truck and she will calculate the site distance once she's able to see a couple of those panels, 2 in particular or more of that target. She'll hit the button and it'll start calculating how much distance there is between that starting point to the target. And then she'll do it the other direction. And if it meets those minimum requirements, they're green lit to move on to the next step in the process. Any questions so far?
So no more tape measures. There was a time, right?
Sometimes batteries die. still allowed. So this one's a little bit hard, but we tried to get the visual here, but trust me, they did have to go through substantial clearing to get this. But there's the target before, where the brush was hindering sight distance to the left. And then thereafter, after they cleared it, it did meet the minimum sight distance there. And which makes a big difference for the safety of both the user of the roadway and for the person coming in and out of the property.
And for the distances that are calculated, it really is, it revolves around safety. It's the motorists on the road, their ability to stop under a certain speed and once an object's seen. So it all revolves around that stopping sight distance typically. So it is one of the three things that we consider is that pillar of safety in the permitting process for not only people that are going to be living in that home, but also the people traveling along the roadway. And that sight lines are so important with also pedestrians and bicyclists as well. So I think this is something that we've taken very seriously in our residential permitting process in commercial driveway. So, and it's an important step in that process. But oftentimes we're having to explain it to applicants on a regular basis. But the premise is safety.
And all is not lost if it does not meet the minimum distances required for us to advance to the next step in the permit process. So one of the steps is, all right, can the object be removed? If yes, and reasonably so, the applicant will take it. If not, like, okay, can they move their driveway location to a different part of their frontage that can get it? So that's something that with Hillcrest, we'll want to look into. It's like, okay, you can't get it here, but if you move your driveway, say 75 feet to the left or right, you will get those minimum sight distances. So that's something we'll say, you can still get access to your property, but you're going to need, I know this is not where you really want it, but this is a place where it's going to need to go for us to issue a permit. Sometimes, yes, sir.
So is there an appeal process in case there's,
Great minds think alike.
there is no meeting of the minds?
That's
on
where I
that
was going
issue?
next. So yes, sir, there is an appeal process. Sometimes there is what we call a waiver that will come into place that will go to the county highway engineer for their consideration in order to, does this make sense for the road commission? Is it reasonably safe for this permit to be issued under said circumstances? And we review that criteria with the now Brent, previously Matt, and decide if this is something that should or should not be issued with what conditions. If the answer is still no, then they do have the ability to come to you guys and appeal their case should they feel that they'd like to take it one step further. That's pretty rare. It's happened a few times in my time here, but it's rare. We like to look for ways to say yes rather than reasons to say no.
Absolutely.
Okay. All right, so that's kind of the nutshell of what we do for residential driveway permits. I'm going to segue over here into utilities now, both overhead and underground. So this gives you two different snapshots of what you would see above ground and then what you could visualize underground. So overhead is always connected to some type of a pole. And the top portion of it is the electrical. And then what you see down underneath that is usually cable and fiber. So could be Comcast, could be AT&T, could be some type of fiber. There's a bunch of miscellaneous fiber companies now out there. So those are what you see down at the bottom, and then the electric is at the top for good reason. We want to make sure that they're the furthest away from the person that's on the ground. Underground can be a little bit more tricky. What we like to do is make sure that it doesn't become what we like to say the wild, wild west when it comes to managing the right of way. We have to know what's there now and foresee what's coming in the future so that we don't have a bowl of spaghetti so that other users, say 10, 20 years from now, have a more difficult time utilizing the road right away. So that's part of the management system where we want them to be placed in certain locations that make sense both for our needs, whatever that might be, and making sure there's space in the future for other users.
Commissioner Green.
So, given that it probably seems safer to put something underground and probably eliminates, or what might happen during a storm, is that kind of the future of placement of lines?
My personal take is no, only because of cost associated with that to
Right.
DTEs and consumers of the world. To put everything underneath. I think in the perfect world, they too would say that would be wonderful, both
Right.
for their stakeholders and for themselves. The cost to do that would be substantial to the point where I don't see that being able to come to fruition.
Okay,
Could be wrong, but that's just my personal opinion.
right. Thank you.
Mhm. So this is a typical utility plan that we would receive, that would come into Cali, that would then give it to one of our utility coordinators, permit coordinators to review. We follow the procedures and regulations. I know there's a lot of lines on here that represent different things, but we want to make sure that we know what utilities are there right now within the road right of way and what they're putting in and where they're putting it in respect to the road and the road right of way. That's the managing part. Want to make sure that we're looking at key aspects, especially in an urban area, are they impacting sidewalks, sidewalk ramps, bicycle lanes? Those are the types of things that need special attention, because sometimes it's ultimate that there's no way around it, that they're going to have to take a sidewalk out. We want to make sure that the applicant is aware that this is going to need special attention so that they take the due measures as needed to protect it during construction and then restore it as soon as possible once they're finished. Maintenance of traffic is what we call just managing the traffic that's out there. That's a key element for us because that generates a lot of phone calls. When the contractor is using the orange signs, chances are they don't realize it's a utility project. They just think it's a road project. Hence, I'm going to call the road commission and I'm going to voice whatever concern I have to the person that answers the phone. Hence why it's important for the utility court, anyone that's performing, but specifically the utility ones, because they're most frequent out there, to give us advance notification so that we know that they're there. We can check up on them, that they're doing things the right way. And then we can provide whatever information to the person that calls to say, oh yeah, that's Michigan, I'm dating myself here. That's DTE gas that's out there doing this type of a project. And if they have any further questions, it can get relayed to the appropriate individual in our permit department. Other times when we don't know about it, we'll say, thank you for letting us know. We'll take a message, we'll look into it, and then we get back to them. But maintaining traffic is very important to us, but as Matt alluded to, make sure that it gets on the weekly road schedule when it has a big impact on our roadways, whether it's a lane closure, a road closure, because frankly, that's the same end result that if they were just putting in a brand new culvert, it has the same implications to the people. And that's important to us to provide advance notification as much as possible.
Question, Commissioner Green?
As I recall, about a year or two ago, I think there was an incident where a gas main line was struck accidentally.
We didn't know it was there, as I recall. And
Right.
It was not.
It was in the
it had been
operations side, I believe.
commissioned, Right,
Right.
Superior Township, wasn't it?
Yes, it was. And I think it was struck by the utility company or something.
It was us.
From what I remember, it wasn't
Members.
marked by the Mystic system.
Right.
And those things do unfortunately happen. I don't know, Adam would have more information if you want to know more about it, but
What kind of safeguards, I guess I'm asking?
well,
do we
that's
have
why
today
that's why the
against that?
Mystic law is in place. So that when anyone has to do any type of underground digging, they call 811.
Mhm.
And then within 72 hours, I believe it is, or 48 or 72, I can't remember. That there are independent contractors that are hired by the utility owners to mark those utilities with flags and paint so that the individual that's doing the digging can take whatever precautions as necessary to ensure that it's not disrupting service or being a hazard to themselves and others.
As part of our system on how we maintain public right of ways and public utilities, they have a right to be within the public right of way. So we have a permitting process for that. But as they operate a facility within the public right of way, they have an obligation to mark their facilities on the MISDIG. So in theory, it all works out, but it's not a perfect system. They may not have good records sometimes of what's live and what's retired. And sometimes they don't get it marked appropriately. And when that happens, we stop what we're doing. We call DT Gas, and they're very prompt in securing the scene and whatnot. And we've got a lot of procedures on that, but it does happen on the rare occasion where things aren't properly marked, or they are marked but not in the right location is a lot of times as well. So it's not a perfect system, but that's the system we have. We work very closely with our utility companies. We're all serving the same public ultimately, but it's a lot of infrastructure to manage and maintain.
Okay, any other questions on utilities?
I had a
Commissioner Sheldon.
question.
Yes, ma'am.
Thank you. They, have a yearly, Mystic has a yearly, like a seminar about, their markings and things like that and what happens. I mean, I know you guys probably know what to do because you've been doing this for years. I was just wondering, do you ever, go to the Mystic, seminar?
I have not been to one lately, which is probably a good reminder that should probably get that on my calendar because I'm overdue.
Okay.
So we as well are part of the MISTIG system because we manage public infrastructure. We will mark for our traffic signal network specifically. A lot of the infrastructure we have, you can visually see if there's a catch basin or if there's a culvert or the roadway itself. A lot of them are pretty evident. What we will mark specifically that is not evident is for our traffic signal equipment. A lot of times we have handholds and sensors, things that may not be readily available. So we will mark for our infrastructure for traffic signals. So we are part of the system. We also will call in MISDIG requests often for our digging activities for our crews. And it's all electronic based now. So I'm sure we have attended in the past. I'm not sure of any recent attendance, but we can look into that and make sure
They do kind of go over the same thing every year.
but it's good to,
Reminders.
as staff transitions occur, make sure everyone's up to speed on MISDIG practices. So good reminder. Thank you.
Thank you.
All right, so we'll segue now into the commercial and development. That's I manage the entire section, but this is part of my job where Gary and I divvy up these types of applications. So there's two components to it. You have the residential, the Lombardos, Pulte's that come in and they subdivide a piece of land into multiple lots to build single family unit homes on it. So this example right here is one that has not come to fruition yet called Fieldstone in Pittsfield Township, Morgan Road to the north, Michigan Avenue, which you do not see to the south there. So what we want to do is manage access to the public road, the drainage that would come from the project, and then what impacts or mitigation that's going to be necessary to our roadway system so that it's not inconvenient to those users. And as we know, so most of you know here, we've gone away from accepting public roads into our network unless it is done via a process that's called a plat. There's two different ways: the Condominium Act, there's a Land Division Act, and then there's a plat act. And as long as they're not applying for a plat, which to my knowledge, no one's doing anymore because it costs too much money to them, those are going to be private roads. Everything you see in this, with the exception of the road that's going north-south all the way to the left, that's going to be a public road because that was planned long before for interconnectivity reasons dating back 20 plus years ago, but everything else would be private. So then we have the commercial. So this is an Amazon distribution center that is likely going to come to fruition at Morgan Road and Carpenter Road. And we do the exact same thing with these, whether it's residential or commercial. How are they going to access to the public road? What kind of drainage impacts it's going to have? And then what mitigation measures, if necessary, are needed to sustain an acceptable level of service on our road network. This is just a snapshot of what we call a traffic impact study. So once an application is submitted to the road commission and given to Gary or I, the applicant is in many cases required to submit a traffic impact study. That study focuses on what type of traffic exists today before the development, what type of traffic is going to be generated to the full build out year, and then what traffic they are going to solely generate by themselves on the road network. And then it looks at it, combines it all together, and then from there it determines, it gives it a level of service grade, A through E, and is under certain parameters, if it degrades to a D or E, they need to, or F, it needs to go back to what it was prior to them showing up. And in many cases, whatever the mitigation measure that can solve the problem, a lot of times it takes it back to an A, which they're not too happy about, but it's ultimately the only, I say they being the developer, it's ultimately the only solution that they have to meet the requirements per our procedures and regulations for them to gain access to that development. But in the long run, it's proven to work. Jim Harmon was instrumental, along with Alan Philbrick, in implementing that process to the point where people follow the Washtenaw County Road Commission process throughout the state on issuing permits for commercial developments such as residentials and commercial aspects. So another feather in our cap. So once the traffic impact study is approved and we're in agreement as to what mitigation measures need to take place, we draft and enter into a road improvement agreement, which comes to your attention periodically for execution, where it's a two-party agreement, where it basically cites what the improvements are going to be, when they're going to take place, and what terms and conditions are necessary for that, both the road commission and the permit holder to fulfill as part of the agreement. Then it goes to circuit court as part of Alan Philbrick for a declaratory judgment. As what's been explained to me is it's called a friendly lawsuit in the sense of the judge just basically stamps it and says, this is legal and binding and I bless it, therefore proceed. It's kind of how it goes. That's in a nutshell how it's been explained to me by Alan. But it's basically a protective measure for the road commission, making sure that we are not subjected to litigation thereafter saying, hey, the road commission shouldn't have been able to do this to me. This is illegal. And then after the project's done, sue us. No, the declaratory judgment is entered in by circuit court judge, protecting us to make sure that doesn't happen. Security, that's a very important aspect as part of this process. We want to make sure that the developer is putting money in place should things go south. It's not often, but it does happen. They do this in two ways. One, if it's a small amount of money, they'll give a check. And whether it's like 30, I say 30 is not small to any one of us, but if you're a multi-million-dollar company, 30 is relatively small. So they will submit a check that's based on what work is going to occur in the road right of way. Let me go into that a little bit deeper. Any work that is in the road right of way minus water and sanitary is they have to put a cost estimate together as to what that's going to cost for them to fulfill that work. We require 100% of that approved estimate to be placed in escrow as part of a security. So that's done either by depositing a check or by issuing a letter of credit, which is basically just a promissory note from the bank saying that if these certain conditions happen, you can file a claim, Washtenaw County Road Commission, for this amount of money to deal with whatever issues you need to deal with, because, for instance, a developer went bankrupt and they didn't fulfill their obligations. Rare, but it happens.
Commissioner Green.
When I was a trustee with Superior Township, one of the issues that we kept facing were home builders were coming in and not completing the project Such a land was vacant for months and years and became an eyesore, and there was no protection. I mean, it's just an embarrassment over and over, and I would see that. Because like you said, on occasion, sometimes things really do go south. What kind of protections can we do to make sure the home builders live up to their responsibility and complete a project the way it was designed and the way that they promised to do it?
Well, I'll start, then Matt can interject his thoughts, but nothing outside of the road right away would be anything we can lawfully hold the developer to. But anything within the road right away that does not meet the terms and the timelines of it, then we have the ability to redeem those securities to finish the work out as necessary. And then in worst case scenario, also take that individual to court to recoup other costs. Matt, is there anything else you wanted to add?
Yeah, I think Mark's point is the security is the motivator. So the money is the motivator. So we will hold that money until we're satisfied with the work that takes place in the road right away. A good example of that, if any of you were to a year or so ago travel North Territorial Road, the paving was performed, but it wasn't satisfactory. There were some issues with cold weather placement. They didn't take all the right precautions. We ended up with an unsatisfactory project. We held the security that motivated them to go fix it. And if they didn't go fix it, we would have cashed the security to hire a contractor to do it ourselves. So that was what motivated that contractor and developer to remedy the situation. So that's a good example of why we keep those securities in place until we're ready to release the permit. And Mark will talk a little bit about that, the tail end of end of the permitting process. So it's been worked very well to date. Letters of credit, I've unfortunately had some experience in cashing letters of credit. Occasionally it happens, but by and large, most of our applicants are pretty reputable, but it can happen. So making sure that we have proper security on file, that's a big part of what Mark and his staff do.
And there's sometimes they just go dormant from the economy. They'll build 25, 30%, and then the bubble bursts, and then it sits there for 10 years until lots are ready to be sold again and homes are ready to be built. Okay, so we'll transition into the issuance of a permit. So these are the types of big construction projects that we would be looking at, that Larry and Josh would be out there reviewing, and also to some extent, if it's utility related, Lauren and Lisa. So to the left there, my left, is Superior Township Sanitary Pump Station on Clark Road. That kind of got mothballed from what I understand. I don't know the particulars as to why that happened, but everything got done that needed to be done within the road right away to the point where we were satisfactory, and it sits there to whatever Superior Township decides to do next with it. To the right is a water main project in conjunction with a sanitary project that's happening in Salem Township as part of monies that were secured by the state of Michigan on behalf of, why can't I think of the name all of a sudden?
Salem Springs
Salem Springs.
Development.
Yeah. Showstack, that's the word I was looking for. So, but the money was granted by the state of Michigan to Salem Township because of the potential development that's coming from Salem Springs. So they are installing various water and sewer lines accordingly to treat their whatever comes in their township in the future. So that's a picture you see there. Construction inspection. So there's really three different aspects to this that we have. We have the quality assurance, making sure that they're following the spec book, whether the state of Michigan or our own. Safety, making sure that things are being done in a manner that's safe to the people that are out there. And then using decisions that need to be made on a daily basis to, everything's dynamic, nothing is static. We have to adjust accordingly, whether it be to work with other stakeholders, internal and external to the road commission that makes sense to do so, or expediting something as necessary because it's just in the best interest of the public to do so. So what I'd like to say is we think on our feet in permits because it is required to do so. We can't just sit and think about things too long. Otherwise, things will go bad. Construction inspection, I knew there was a slide that got out of order. My apologies. This should have been the slide before. So this is what we call a pig catcher station in Ann Arbor Township. So a pig, what's a pig? It is a mechanism that they put in a pipeline that inspects it, cleans it out and inspects it. And why it's called a pig, back in the day, they just put all kinds of debris in there and it squealed like a pig when it pushed through the pipe. So that's why they call it a pig. And ultimately, this device that's going through the system needs to be caught. It needs to come to a receiving station. So hence it was called a pig catcher station. So that was in Dixboro Road and Geddes Road in Ann Arbor Township. And then you just have paving of left turn lanes. This is a development called Monarch Estates in Pittsfield Township, where they were putting in curb and gutter and putting in drainage improvements underground in this case, in addition to putting in a center left turn lane so that there was a safe space for people to turn left without backing traffic up to behind them and being potentially collision for a rear end. Yes, ma'am.
Commissioner McCollum.
Yeah, I believe there's a video that shows how the pig catcher works. I think, yeah,
Remember, send it to you.
yeah, sent it to me and, it was kind of gross.
There's a lot of crud that comes out of that thing.
But I'm glad it exists.
And that's a requirement by the feds, that
Okay.
they do that every, I think, 7 years to maintain the integrity of the pipe. So we don't have incidents that would be detrimental to the public. All right, sorry about that slide misplacement. So then we have our communications. So this is where we work with Tiffany and her team as far as we know a project's coming. They're gonna have some type of restriction on the road right away, whether it is a flagging operation, whether it's a road closure. So we would treat it as if it's one of our own, talk about the when, where, and why, and then get background information, who they should contact should they have any questions. So this is an advisory. Sometimes it just goes on our weekly road schedule that is managed by Tiffany and Emma. And it's to a lesser degree not an advisory. I don't get into particulars. I'd let her explain it, but bottom line is we're doing our best to communicate with the public so they know what's going on. The permits that we've issued. Then finally, we get to the permit release. So what happens before we release the permit? Make sure that all their invoices are paid, that they've incurred cost along the way. We make sure that they've fulfilled their obligations in the road right away. We call that a punch list, where we go through making sure that if there's something that are odds and ends that need to be tightened up, give them a list and make sure they take care of that before we clear the permit. And then after both of those things are done, we would release the funds, the letter of credit or whatever cash we have in escrow, to returning that to the developer, less any unpaid invoices. Making sure the books get balanced. Kelly does a fantastic job doing that. That's my presentation.
Any questions for Mark?
Very good. I really learned a lot.
Thank you.
Welcome. Well, you're always going to, work through Brent if you have questions and Matt, and they can come to me as needed to provide the information that you're seeking. Thank you. Thank you. Have a nice day.
Mr. McDonald, anything?
I had nothing further for the working session and but that concludes the information we wanted to share today.
May I have a motion to adjourn the working session, please?
So moved.
Support.
Roll, please, Aaron.
Commissioner Joanne McCollum.
Yes.
Commissioner Rod Green.
Yes.
Commissioner Gloria Yamas.
Yes.
And Commissioner Bart Fuller.
Yes, we are adjourned. See everybody at 1 o'clock.